Honorable the President.
Honourable Senators, we are just awaiting the Attorney General's technocrats. They should be here.
Clause 3.
The question is that Clause 3 stands part of the bill. There is one amendment circulated, and that is by Senator Ramdeen. Senator Ramdeen.
Thank you, Madam Chair. Madam Chair, through you to the Attorney General. Before I get to the proposed new subclause I wanted to propose, AG, is it necessary for us to have 3.1? Or is it just as a matter of completeness?
Well, the Leader of the Opposition proposed 3.1 in those specific terms. I think as a matter of completeness, it does make it abundantly clear, just in case there was any doubt.
I had proposed, AG, the insertion of a subclause 3.3, save as expressly agreed by the Director of Public Prosecutions in a plea agreement. Nothing in this Act affects the powers conferred upon the Director of Public Prosecution under Section 90 of the Constitution to preserve the power that the Director had indicated in the Joint Select Committee, that the power that he exercises now. I think we should expressly preserve that power in the Act, because this Act actually deals with the power that, deals with a power to enter into a plea agreement, which is a power that the Director of Public Prosecution has stated openly that he exercises on this Section 90 powers. I think as you've indicated before, I think it's a matter of completeness just for us to confirm that nothing is taken away from him to do that.
Just through you, Madam Chair, just give me a moment. I personally have no difficulty with the recommendation, Senator Ramdeen. The caution coming from the drafters is that the supreme law is the supreme law and that statute can't erode the powers of the DPP, particularly in Section 90 of the Constitution. So from the CPC's perspective, there was a view that it could be viewed to be superfluous. I personally don't think that it would take us in any direction otherwise, because this sort of law couldn't derogate from any of the powers or circumscribe the powers of the DPP. I don't know if that flavors the fulminations on your team through you, Madam Chair.
I thought that would have been the answer to it. I just think that is something that we should perhaps expressly preserve. But I hear the argument that the Supreme Law would nothing can override the Section 90 powers. So it really is a matter for you.
Could we perhaps?
Madam Chairman, if I could just put in my usual 2 cents, with your leave. I don't see that it fits easily with what subsection 2 is doing. Subsection 2 is talking about the preservation of the other opportunities that an accused person has to plead guilty without entering into a plea bargain or to plea bargain outside of the act. So to put in a section to say that Section 90 of the Constitution is preserved really bears no logical or contextual link with what is contained in subsection 2. That's just my thinking.
Appreciate it, Madam Chair.
Senator Ramdeen, are you?
Yeah, I can withdraw it. I'm fine.
You will, great. All right, so you withdraw. And new subclause 4.3, Senator Ramdeen.
That's in clause 4.
Oh, I apologize. Yes, so, Honourable Senators, the question is that clause 3 now stand part of the bill. Those in favour say aye. Aye. Any against? The ayes have it. Clause 3 now stands part of the bill.
Clause 4.
Honourable Senators, the question is that clause 4 stand part of the bill. Now, with respect to clause 4, just one second.
I'm sorry.
Senator Ramdeen. Senator Mark has proposed an amendment, and Senator Ramdeen has an amendment as well. So we will deal first with Senator Mark's proposed amendment. Senator Mark?
Yes, Madam Chair, consistent with our earlier recommendation in terms of an amendment to clause 2, we are just consolidating our position in clause 4, and we have already submitted our arguments as to why we do not, we would like the word suspect to be removed wherever it appears in clause 4. So I don't need to detain you any longer. You know what my arguments are.
All right, Senators, the question is that clause 4 be amended as circulated by and proposed by Senator Mark. Those in favour say aye.
Aye.
Any against? No. The noes have it. Therefore, this amendment is not accepted. Senator Ramdeen.
AJ, I just want to ask for your...
Before you go into your proposed amendment, you have 4 sub 3,
yeah.
but I think it should be 4C.
Yeah. AG, is there a clause in your clause 4 as proposed in the bill that requires the prosecutor to take into consideration the interests of justice? My purpose for the amendment, AG, perhaps I can say so, is that I wanted to include what is in Roman 1, 2, and 3 as the factors that a prosecutor ought properly, in addition to what you've put in your subclause, to take into consideration in entering into a plea agreement, in the public interest, of course.
To answer your question squarely, whether there is a interest of justice consideration on the part of the prosecutor, no, there isn't an express statement to that effect. I note the language that is being proposed, that it's the introduction of the interest of justice to enter into a plea bargain. I just wonder whether this can potentially collide in that one-off opportunity that a prosecutor might have where the interest of justice doesn't meet with these factors, and I accept that they're not exhaustive factors because you've used the word including in the chapeau to the subclause C that's proposed. We had really sought in dealing with this to just really bring the matters before the court at the plea agreement stage. When we get to clause 19, move onward. But that we really leave it up to the court to look to the interest of justice factor and not so much the prosecutor.
Well, I want to suggest, AG, that the prosecutor, in discharging his function as a Minister of Justice, as he's mandated so to do in our system, in our criminal justice system, that I think to shore up the fact that in discharging those functions, there are certain things that he ought mandatorily to take into consideration. And the fact that we've listed them and they're not being exhaustive, it creates two options. One, it provides a safeguard to the prosecution and to the accused person that these factors are factors that ought properly to be taken into consideration. Some may weigh against, some may weigh for. But it also provides, in being non-exhaustive, in the prosecution going outside of those factors that have been considered there, to make a decision, as you've indicated, perhaps in a one-off case, to still have a plea agreement entered into that may not be covered by these factors. So I'm not suggesting in any way that the powers that are given to a prosecutor are circumscribed in a way that prevents him from entering into a plea agreement, but it more the purpose of suggesting that there are these factors that ought properly to weigh in the mind of the prosecutor in determining whether to enter into a plea agreement or not, is that it provides a certain degree of a safeguard to both the prosecution, because some of the, like I said, some of the factors would weigh in favor of the prosecution, some of the factors would weigh in favor of the defendant. And I think the added advantage of having it is that it allows, as we did with the sentencing guidelines, one of the things that we had discussed was that the fact that it is in the statute, it opens the eye of the prosecutor, and it doesn't leave it to the prosecutor to say, well, I'll consider A, B, and you leave out C.
I do understand, through you, Madam Chair, the intent. What concerns me here is about the fit in the plea agreement, because Clause 4 is really intended to speak to a plea agreement, who enters into it, that it is between the prosecutor and the accused person or suspect, and really it's intended to be that the accused agrees to a particular course and that the prosecutor agrees to a particular course. The clause itself doesn't speak to the quality of mind of either of the parties to the agreement, to the accord, either on the part of the accused person or suspect on the one hand, or on the part of the prosecutor. I'm just wondering whether introducing the interest of justice argument here may take us into a zone which may tend to fetter the use of this type of position by putting the qualities of that.
All right, can I suggest this, AG? Can we take out the interest of justice and leave that concept out and say that in determining whether to enter into a plea agreement, you wholesale put in the factors and leave out anything to deal with the interest of justice that may or may not circumscribe the actions of the prosecutor or the accused. This is not to affect the state of mind of the accused. This is really to ensure that the prosecutor, remember at the end of the day, AG, your policy position, which you have indicated openly, is that you are not going to compromise on the criminality aspect. Having accepted that, I think we should then consider the other ways outside of criminality that we can actually, this is not in any way going to impede our prosecutor. This is actually going to assist the prosecutor in coming to a decision and ensuring that certain material, it may be that you don't want to put in all, but it actually lays down some factors that the prosecutor would want to take into account. And like I said, you can leave out the interest of justice.
Madam Chairman, if I may respectfully suggest, I think Senator Ramdeen's suggestion that in the interest of justice should be included is one that he should not resile from. He should hold on to it, because I think that's the fundamental thing in all of this. if I could just suggest that maybe Senator Ramdeen could think about, for the purpose of this act, a plea agreement is an agreement made in the interests of justice between the prosecutor and the accused person.
Good suggestion.
So it doesn't take away from what the legislation intends to say, but it also reminds the parties that such an agreement must be made in the interests of justice before it can be brought to a court and accepted.
I think that suggestion, I think that my difficulty with what Senator Ramdeen, through you, Madam Chair, was proposing was the prescriptive approach, and I was wondering whether that should be subsidiary, for instance, Rules Committee or other aspects or practice directions. But I think that it gives a very useful qualification to the quality of the agreement and allows for a little bit more safeguard for the courts. I think that it's a very useful combined submission on the part of both senators. So, Madam Chair, for the purposes of this act, a plea agreement is an agreement made, we can go right there, in the interest of justice, and I think that that is a very useful improvement. And actually it ties into the language of clause 25, which comes later, which speaks to the interest of justice.
May I ask Senator Ramdeen? Senator Ramdeen? That's all right. The amendment that you circulated, are you withdrawing it? And now we will propose the amendment that I've just...
Can I just clarify? Now that we are inserting it there, AG, what are you doing with the factors?
The factors recommended in the proposals offered by the opposition. Mm-hmm. I propose to leave it out, and I'll say why. There's actually a code for prosecutors which operates in Trinidad and Tobago, which speaks in detail to this. I found the reflections very useful and good fulmination for us, but it struck me that this was more of a subsidiary type of a factor which should be particularized in rules or in regulations or practice directions. And I've just found, thanks to our team here, the code for prosecutors, which actually is published and enforced right now. So I was hoping that we would catch the flavor of the elements by including in the interest of justice as proposed by Senator Choate, because that would allow for the court to grow the area up and not to be how should I say, prescriptive just by the statutory point. I do accept that putting down statutory posts helps to cause the court to reflect upon factors, but if we go to clause 25, we'll see the court may reject a plea agreement entered into between prosecutor and accused person if the court considers that it is in the interest of justice to do so. So I think that we can perhaps bridge the gap between the two by the words as proposed by Senator Choate.
No, I'll reformulate my amendment to request to insert after the words for the purposes of the act, comma, in the interest of justice. So that will be the reformulated amendment, Madam Chair.
Sure, I would have no objection to either place for the inclusion. So instead of after the word may, it can come after the comma, after act, comma. Is that what you're saying, Senator Ramdeen?
I had thought that is Senator Choate. Is that where you?
No, we were looking at made.
Made.
After the word made.
Well, I'll go with what Senator Choate suggested, which is that to insert after the word made in the interest of justice.
Okay.
I mean, what I'm asking you is what you had circulated here.
I withdraw that
you withdraw
amendment and propose.
Yes. So, honourable senators, the question is that clause 4 be amended as follows. by inserting the words, well, I'll read it. For the purpose of this act, a plea agreement is an agreement made, new words, in the interest of justice. So you're inserting those words, and that will be the amendment to clause 4.
As far as Senator Ramdeen is concerned, Madam Chairman, or generally?
I thought generally, because Senator Ramdeen has withdrawn the amendment that he had circulated. Is it that you have another amendment to propose?
Yes, please, if I may.
Sure.
4B3. This was the one when I had been speaking, I thought that this was capable of abuse. So I am respectfully proposing that after the word suspect, we add the words where there is evidence to sustain a charge against such persons.
Attorney General.
Sorry, would you mind just repeating that for me, please? So it's after the word suspect.
It's 4B3.
Yes.
And it continues. After the word suspect, I believe you'll have to take off the semicolon. And it'll be where there is evidence to sustain such charges against such person.
Sustain a charge against such persons.
Such a charge.
To sustain.
But it talks about an undertaking not to institute charges.
So it would be charges against such persons.
Correct, yes. Attorney General, yes?
Against such person.
Yeah. Such charges.
So it would read that the prosecutor agrees to take a particular course of action, including an undertaking not to institute charges against family members or friends of the accused person or suspect where there is evidence to sustain charges against such charges against such persons.
Yeah.
Sure, it's agreeable.
Sure. Senator Sturge?
Am I allowed to make a point on Roman numeral 7, or are we?
We're still on 3. We are on B3.
Oh, I see.
Yeah. So the Attorney General has indicated that he's amenable to that amendment.
Thank
So
you,
we
Madam
now-
Chairman.
Senator Choate? Oh, sorry.
No, Madam-
We now turn to page 7 and Senator Sturge.
Roman numeral 7.
Yes.
An undertaking that a conviction pursuant and so on. Now, I'm not clear about a number of things with respect to Roman numeral 7. But in any event, I'm wondering whether or not this should be removed, because this is not an undertaking a prosecutor can give, that a conviction pursuant to the agreement will not be used as evidence at any trial. That is a decision for a court. And the way it is worded, I don't know whose trial, if it is the trial of the accused or suspect who's the subject of this part, or it's wide enough to cover any other trial of someone else. If it's a trial of someone else, and that is open to inference on the wording of this clause, then one would be depriving those other persons from properly representing themselves, because one is entitled, as it is, to make reference to the character or the bad character of this witness when they come to trial to defend themselves and he's giving evidence against them. So this is not an undertaking that a prosecutor can give. So I'm wondering whether this clause should be removed.
Attorney General.
Very interesting submission, particularly as it relates to against whom the bad character evidence is going to be used. I think you could understand the natural nexus to the accused himself, or to the, well, particularly there, but in the broader section, I wonder it should certainly include where we just dealt with the family in subclause 3. May I, through you, Madam Chair, ask for Senator Choate's view on this as well?
Senator Choate.
Madam Chairman, I agree with Senator Sturge, because the law as it stands is that the Evidence Act has been amended to permit applications to the judge to permit bad character evidence into the course of a trial. And the bad character doesn't always have to come from the accused person. It may be the bad character of a witness or more than one witness for the prosecution. So I agree how this is worded. First of all, it doesn't take into account that it is a judge that has to make a ruling, and it seems to be carving out the judge's discretion, or carving away the judge's discretion. And secondly, it's unclear.
I was just asking where refreshing my memory as to where the recommendation had come from, and it had come about out of the workshops and consultations as a proposed inducement for people to actually use the system. One of the reasons why they should use this. But I am very cautious about the consequence that really this ought to be a judicial function.
Well, it's not that it ought to be with, sorry, Madam Chairman, through you, if I may, it's not that it ought to be a judicial function. It is a judicial function according to another piece of legislation.
Yeah, which we would be impliedly affecting by virtue of this, because this would be subsequent law. I would have no objection to moving it out of an abundance of caution.
So we are proposing that sub 7 be deleted. Okay?
Madam Chairman, are we moving on to 8?
I have to, yes, yes.
8, Madam Chairman,
Go ahead.
I'm sorry, Madam Chair, just with the indulgence of the Senate, I'm just taking a quick consultation with the technocratic team. Yes, thank you. I apologize, Madam Chair. I believe you were allowing Senator Choate to raise number 7, is it?
8.
8?
well, I suppose 8 would now become number 7.
The consequential amendments will follow.
Yes.
Yes.
I think what you want to say in this one, Honorable Attorney General, through you, Madam Chairman, is a promise to proceed summarily rather than indictably. Is that the intention?
Yes, it was.
Well,
yes, we can
I
reformulate.
think perhaps it should, I propose that it be amended to read a promise to proceed summarily rather than indictably.
Yep. So that we can strike the words by complaint rather than by information and insert instead, after the word proceed, summarily rather than indictably.
Yeah. I will just read it. A promise to proceed, you're deleting the words by complaint and you're saying a promise to proceed summarily rather than indictably. So you're taking off the words by information, correct?
Yes, Madam Chair.
Yes.
Thank you.
Members, can I now put the amendments to the Senator Ramdeen?
Yes.
Senator Ramdeen.
Sorry, I'm
Yes.
sorry, Madam Chair. Madam Chair,
Yes.
through you to the Attorney General. In clause 4, you have the second to last line, summary trial rather than trial by indictment. It should be trial on indictment, as I understand it. On page 6, AG. Second to last line.
Forgive me.
Second to last line, on the bottom.
I see, on Roman 4,
Yeah.
apologies.
Yeah.
And undertaking to recommend summary trial rather than by, yes, on indictment. Thank you, Senator Ramdeen.
So members, I will now put all of the amendments to clause 4, and I ask all members if you can just pay attention so we can get through this. So clause 4, the question is that clause 4 be amended as follows. For the purpose of this act, a plea agreement is an agreement in the interest of justice, made in the interest of justice, between the prosecutor and the accused person or suspect.
Yes.
So you're inserting the words in the interest of justice. And then when you go down to B3, you're adding the words, where there is evidence to sustain such charges against such persons.
Yes.
And then in 4, you are deleting the word by and substituting on.
Yes.
You are deleting sub 7 completely. And then in 8, a promise to proceed summarily rather than indictably. So
Yes.
you're deleting the words by complaint, by information. All in favor, say aye.
Aye.
Any against? The ayes have it, the amendments are accepted. The question is that clause 4 as amended stand part of the bill. Those in favor say aye.
Aye.
Any against? Clause 4 as amended. Clause 4 as amended stands part of the bill.
Clause 5.
The question is that clause 5 stand part of the bill. Senator Ramdeen has circulated an amendment. Senator Ramdeen.
I was wondering, AG,
Yes.
having regard to the way in which you have, through you, Madam Chair, having regard to the way in which the section is drafted, a plea discussion may be held and a plea agreement concluded at any time before conviction. All of the A, B, C, D, and E would be caught if the section stops with a full stop after conviction, because all of these circumstances as defined by A or E can't happen at any time before or they all happen before conviction.
Yes, through you, Madam Chair. Save that the view in the House between the respective benches was that they need to cleave the suspect, that is the person before charges are instituted, was the issue. And because we're talking about a plea discussion as opposed to the agreement, we did have to factor specifically for A, 5A, which is before charges are instituted.
Well, if we do that, at any time before conviction, including A, and then having regard to the fact that you're not moving on suspect, then we wouldn't have to have B, C, D, or E.
Yes.
Because once you include A, you catch suspect, and then everything else that comes after. If he's charged, you're already caught before conviction, and if he's not charged, you're caught by E.
Yes. So we could simplify the language. Yes.
And take out B, C, D, and E.
Yes.
Attorney General, you're in agreement
Yes, Madam Chair.
with deleting B, C, D, and E.
Yes,
correct?
Madam Chair.
Senator Mahabir?
Yes.
Thank you, Senator Ramdeen.
Thank you, Madam Chair. Madam Chair, I too had a concern similar to Senator Ramdeen, but my concern is linked with 5A, which the Honorable Attorney General is keeping, but also the link with what occurs on page 31 on Form 7B. You see, on Form 7B, page 31, and I'm linking it to 5A, I, Justice of the Peace for the County of whatever, hereby certify that the above plea agreement was signed by the prosecutor and the accused defendant, but I am seeing that in 5A, a suspect is going to enter into a plea agreement, and this particular suspect, once he enters into an agreement under Form 7B, he has no legal representation. So is it fair that a suspect, 5A, will sign a form, page 31, 7B, without legal representation? I would have thought that in the interest of justice that you would have had, and the accused defendant and his attorney. You see, I'm seeing no attorney present here.
We have a separate form for that. So what we've done is we provided a form for a suspect.
Yes.
And where the suspect does not want to be represented, as he's entitled to, we're putting the caution that a JP must be there.
Okay.
And it must be recorded as well. And when we have a suspect who's represented, we have a separate form where the suspect and the attorney participate.
Madam Chair, with respect to what the Attorney General just indicated, even if a Justice of the Peace is present during that process, a Justice of the Peace is not legally trained and cannot provide the kind of assistance or advice in the detail that a lawyer can. So I'm wondering, perhaps, given that when persons are in custody, legal aid lawyers are, as a right, sent to visit these persons in prison, whether we should remove Justice of the Peace and put attorney at law, so that they are on even terms.
I thank, through you, Madam Chair, Senator Sturge, for the observation. It's true that duty counsel are appointed on the first call, but they don't stay for the entire time. And that was the problem that we had with the utilization of duty counsel under the amendments to the legal aid and advice, legal aid advice and authority legislation that happened. We looked back at this and we really reflected upon the judge's rules. And that's how we came up with the Justice of the Peace. You're right, they're not legally trained. At best, they're a witness on forms which have fallen into odium. I mean, written statements, confessions before JPs, etc. So the idea with this is that the judge would have, at the plea agreement stage, much more care to exercise with the unrepresented person and the interrogation. But I didn't see that we could have put the duty counsel in there because there are lacuna in how that system operates.
I see.
Senator Ramdeen, just to clean up the matters, will you withdraw?
Can I withdraw my
Yes.
my proposed amendment
To clause
and propose
5.
to clause
Yes,
5 and propose
that had been circulated.
as circulated.
Yes.
And propose that in clause 5 we delete items B, C, D, and E.
Yes. That,
and merge clause E into 5 to have
Yes.
one singular clause.
Sure. So let me just read how the clause should be read now. A plea discussion may be held and a plea agreement concluded at any time before conviction, including before charges are instituted. Yeah? So you're going to take off that dash and you're going to take off the E as well. And then you're going to delete B, C, D, and E. Yes?
Yes.
So, Honorable Senators, the question is that Clause 5 be amended as follows by deleting B, C, D, and E, and to allow the clause to read as follows. A plea discussion may be held and a plea agreement concluded at any time before conviction, including before charges are instituted. Those in favor say aye.
Aye.
Any against? The ayes have it. The question, therefore, is that Clause 5, as amended, now stand part of the bill. Those in favor say aye.
Aye.
Any against? Clause 5 as amended now stands part of the bill.
Clause 6.
The question is that clause 6 stand part of the bill.
To you, the Honorable Attorney General, I was just wondering if when you go back to the definition section, clause 2,
Yeah.
and one reads that the definition of prosecutor means the director of public prosecution or an attorney at law authorized in writing by the director of public prosecution to engage in a plea discussion or conclude a plea agreement. And then we come back to clause 6. Is it that it is envisaged that by virtue of the definition you have the authorization of the director unless the director is doing it himself? And
It appears to be superfluous.
well, it does.
Yes. So the question, it invites a consideration that you have two forms of written permission. But prosecutor itself says that that's the person. The preference in drafting is that the substantive clause 6 really ought to exist the way it does. The definition, even though it when read with 6 is superfluous, is true. But I think that the definition can be cleaved insofar as prosecutor is used elsewhere in the bill. It's meant to take care of the use of the definition of prosecutor or the use of the term prosecutor wherever it appears. But you are correct that 6 does say written permission, and for you to be there in the definition in the first place, you need written permission. So even though it appears superfluous, I still think it is necessary.
As you please.
And at worst, it's just, worst case scenario, it's just superfluous.
Honourable Senators, the question is that clause 6 now stand part of the bill. Those in favour say aye.
Aye.
Any against? The ayes have it. Clause 6 now stands part of the bill.
Clause 7.
The question is that clause 7 stand part of the bill. Senator Ramdeen, you have circulated amendments.
Madam Chair, I know that the AG's position, this is one of his policy positions, and I wanted to just flag an issue that I think requires some consideration by us all. When the 1999 Act would have been passed and an offence would have been created by that Act, there is, by virtue of the most recent Supreme Court decision in Miller, which is the Brexit appeal to the Supreme Court, there were 11 Supreme Court judges in that matter, and the core argument there, AG, was that where statute overrides the common law is eclipsed. That goes all the way back to AG and the Kaiser Royal Hotel in 1923. I'm wondering whether we've properly considered that these common law offences, for which we are as a policy position taking as being offences that are available to someone who, a prosecutor being someone who's in a public office, are we properly considering that those offences may have been eclipsed when the 1999 Act would have been enacted, because it would eclipse the power under the common law? And then now what we are doing is that we are removing the 1999 Act, and whether the common law power to go after these offences will revive because the Act has now been repealed. And it is quite a serious matter.
No, I'm admiring the sophistication of the argument.
No, but it's quite a very serious argument, because I'm not sure that having eclipsed the common law powers, that the common law automatically revives.
Yeah. I do, through you, Madam Chair, think that it's a very useful consideration. Out of caution, we should consider it. My own view, when I asked for the counterbalance, because this was raised in the debate, and the question was, well, what is the foil to, the counterfoil to this form of turpitude, was the argument of the common law. But I would think that if statute had eclipsed common law, it was specifically in relation to an offense now described under statute.
Well, before you just push that further, it would have to be that the statute would have been creating an offense, the facts of which would be overridden by what the offense would have been under the common law. So the actus reus for that offense would have to be the same as the actus reus for the offense when the 1999 Act would have been enacted.
Yeah.
So let's say we have not passed this legislation and someone would have been charged under the 1999 Act, and then for some reason you on the indictment you charge the person under the Act and under the common law, then you can raise an argument, a very strong argument, that you cannot go proceed under the common law because that the common law no longer exists. Now, we have a very strange situation where we have created an offense. That offense has to be overriding what you would have been charged with under the common law. And now we are removing that statute and we are putting back in place a statute covering the same ground, but we are not creating an offense. And one wonders whether, let's just try and look into the future, somebody's charged for misbehavior in public office or perverting the course of justice for offense of entering into a plea agreement by virtue of whether it be coercion or one of the prohibitions that we've engaged. That person is able to go to court and raise an argument that you cannot charge me under the common law because the common law doesn't exist anymore. Parliament has eclipsed that. That cannot revive, and therefore that's the end of it. So you cannot charge me. Now, that leaves you in the position where you have to consider whether the disciplinary powers of the JLSC under the regulations and under the Act is really enough to be able to say that our safeguard against persons performing an illegal act and coercing somebody to enter into a plea agreement unlawfully is something that you are able to say, I rest my case on the fact that I have an alternative. But that alternative is very weak.
If I could respond.
Madam Chairman, if I may. These deep legal arguments, I'm not sure if I have got it right, but my understanding is under the old legislation, particular offenses were created. I would imagine that those offenses were alive along with a slew of common law offenses which are still alive, such as attempting to pervert the course of justice and whatnot. So the creation of the offenses under the previous legislation does nothing to permit someone to now argue in a criminal court that it is an abusive process to prosecute him for a common law offense because a repealed statute had created statutory offenses. Essentially, that is what we are addressing, if I understand it. So I don't see that there is any difficulty at all with respect to, you know, whether offenses need to be set out in the Act. I think clearly you can still prosecute people for a variety of common law offenses.
Madam Chair, Senator Cho took the words out of my mouth. I was going to put it in summary as, I would have viewed it as the common law offences running concurrently with the offence under Section 5 of the 1999 Act, and that in any event, if an argument that there was an eclipse happening, it would have to be if the offences were so stated as to be on exactly similar terms, because it's still open to the person who's laying the charge to describe the elements of the crime within terms which were beyond Section 5. So the misbehavior in public office and the conspiracy to pervert the course of justice or perverting the course of justice could have been described in other ways, so that we're beyond the strictures of a like offence, similar to Section 94 of the Summary Offences Act. So I do think that it's a a good consideration of quite a novel argument, and I thank Senator Ramdeen for raising it. But I think that we can perhaps posit for the record, as we have, in case Pepper and Hart is called for any aid in interpretation, that we consider the offences to have run common law and statutorily side by side.
Well, I'm wondering, for the avoidance of doubt, since there may be some ambiguity in what the true legal position is, perhaps we can insert a clause that this is without prejudice to charges being brought at common law for misbehavior in public office or perverting the course of justice, so that it is very clear.
That would, in and of itself, through you, Madam Chair, take me back to the realm of how large Section 5 caused a dissuasion in the existing law. Because it's true, it may be viewed to be, how should I say, a sleight of hand to, on the one hand, acknowledge that the common law offences exist and not state them expressly. But I'd prefer to omit it.
So, Honourable Senators, I think we've had enough discussion on this clause.
This one? I would like to say something on this. If you allow me, ma'am.
Sure.
I don't understand why the Attorney General, who understands that in what he calls the common law realm, people can be charged if they commit offenses. And we would like to explicitly state in the current legislation that we are dealing with, or bill, those offenses so that it could serve as a reminder, Madam Chair, to those who are playing with people's rights and life, that if they violate or they engage in what the amendment is proposing, that there are consequences to be had. I don't see what is the harm in incorporating these amendments into the legislation.
So you are speaking on behalf of Senator Ramdeen's amendment?
Yeah, I'm supporting these amendments, ma'am.
All right. Attorney General.
Thank you, Madam Chair. I thank Senator Mark for reviving the advocacy behind the particular recommendation that we criminalize this. Yes, please.
I was just wanting to ask you this so you could answer both at the same time, because the answer might be the same. We are saying that if you conduct yourself improperly as a prosecutor, you can go under the common law and charge them, and you're accepting that that is the position, right? If that is so, why are we saying that no proper inducement should be used? Because in any event, if you use an improper inducement, you are not going to use the act to provide the basis to charge a person at common law.
I can answer that. So, firstly, in respect of Senator Mark, the policy position that we're taking is in line with the policy as developed between 2014 to now, that Section 5, as originally casted with the statutory offence for improper inducement, was a dissuasion to the use or proper utilization of the Act itself. But in particular, the reason why we're putting in 7, no improper inducement, bare, hanging, no sanction,
right,
is specifically to bring it to life in clauses 25 and 30 later on, where we allow the court the ability to set aside or reject the plea agreement in 25 as we do, or set it aside in clause 30 as we do as well. So it was for a different purpose. It was to provide the anchor in clauses 25 and 30 to allow the court to set aside or to allow how should I say, relief for the accused or suspect who is now in the realm of the plea agreement.
So, Honourable Senators, the question is that clause 7. The question is that clause 7 be amended as circulated by Senator Ramdeen. Those in favour say aye.
Aye. Oh no.
Those against say no.
No. Division.
It's an important point.
Mr. Khan,
No.
Mrs. Batiste Primus,
No.
Mr. Rambara,
No.
Mr. Sinana, Mr. Moses,
No.
Mr. Hussain,
No.
Miss West, Dr. Henry,
No.
Mr. Singh,
No.
Mr. Coppin,
No.
Mr. Cummings,
No.
Mr. De Freitas,
No.
Miss Bash,
No.
Mr. Dookie,
No.
Mr. Mohammed,
No.
Mr. Sinanan,
Yes.
Mr. Sinanan,
No, Madam Speaker.
You voted already.
He supported our cause. He supported our cause.
Mr. Mark,
I'm beg your pardon. Yes, ma'am.
Mr. Solomon,
Yes.
Mr. Meaton,
Yes.
Mr. Ramdeen,
Yes.
Yes.
Mr. Samuel,
Yes.
Mr. Sturge, Dr. Mahavir,
Abstain.
Mr. Shrikishu,
Yes.
Ms. Choate,
Abstain.
Mr. Richards,
Yes.
8 voted for, 14 against, 2 abstentions.
Senators, in request of the proposed amendment, 14 members voted against, 8 members voted for the amendment, and there were 2 abstentions. So the amendment was not accepted. The question is, therefore, that Clause 7 now stand part of the bill. Those in favor say aye. Aye. Any against? The ayes have it. Clause 7 now stand part of the bill.
Clause 8,
The question is that Clause 8 stand a part of the bill.
Madam Chairman,
Yes?
it's a question really that I have for the Honorable Attorney General. It is important that the person, the accused person, whether he or she is represented or not, should know what is the strength of the evidential material which would be encouraging him to enter into this kind of discussion. So I am not sure, I haven't thought it out well enough to make a proposal to say that there should be full disclosure before this process begins, or at least certainly before it is concluded. But I was wondering whether you would be minded to put something in, put a clause in, or a phrase or subsection to say that full disclosure should be made before these discussions are embarked upon.
Well, before you answer, Attorney General, I think Senator Ramdeen also has circulated a proposed amendment to Clause 8. Senator Ramdeen?
No, I had asked for it to be deleted.
Well, that's the
Yeah,
amendment. Yes. So you need to just explain. Yes?
What I wanted to, perhaps, if you don't, which I suspect that you don't agree that it should be deleted, I'm looking at the way in which it is phrased. In the discretion of the director, charge is justifiable, having regard to. I was wondering whether it is. I understand you have the administration of justice there, and then we had used the term of the interest of justice. And I was wondering whether we should keep the interest of justice instead of the administration of justice, having regard to the fact that we're using that in 25, and we've also used it in the clause that we inserted before.
Senator Ramlin, if I could just interrupt. So you're not asking for it to be deleted?
No, in the first instance, I'm asking for it to be deleted. Yeah. If the AG doesn't agree for it to be deleted, which I indicated, he may not be minded to. We have used the term, the interest of justice, in clause 4, and we've also used the interest, the clause, the interest of justice in clause 5. And I'm wondering if we shouldn't simply keep the terms singular, so that we...
So where you have administration of justice, you want to put interest of justice? Okay. Attorney General?
So yes, we propose to maintain clause 8 because we want to put the prohibition in certain circumstances. As to the redrafting that is potentially available in 8B Roman 1, if I could just read aloud, Madam Chair, to make sure I've got it right. So, a prosecutor shall not initiate or participate, etc., to an offence that, B, does not adequately reflect the gravity of the provable conduct of the accused person or suspect.
AG, can you, I was wondering, before we actually even go further than that, this concept of provable conduct, I don't know, Senator Choate and Senator Sturge would be more knowledgeable than myself on these issues, but I don't understand where the concept of provable conduct comes in, because we had taken out...
It should be admissible evidence.
We had taken out provable facts in at page 3 in the definition of improper inducement, because we had...
So it came from section 7 of the existing act, which is where the prohibition against plea discussions arrived, and it is specifically stated as inadequately reflects the gravity of the provable conduct of the accused person unless, in exceptional circumstances, the charge is justifiable in terms of the benefits that will accrue to the administration of justice, the protection of society, or the protection of the accused. So we had lifted it from the 1999 legislation.
Senator Stewart.
Madam President, with respect to the issue raised by Senator Choate, I'm wondering, with respect to 8A, if we can perhaps, to address that issue, after the word evidence, insert the words available at the time of the initiation of such discussion, because what one has to take into account is what is the mindset of the accused, or the suspect, when one initiates a discussion with him, a plea discussion. So if one is initiating a plea discussion with a suspect, not only must there be full disclosure, but his mindset and whether he ought to proceed to embark upon any discussion would be based on the evidence available at the time. So he may start off, or if it's not amended and you say is not disclosed by the evidence at what stage? Because they may not have sufficient evidence or any evidence at all when they initiate the plea discussions, but by the time or later down they may have such evidence, and therefore he would have been induced at a time when he ought not to have been induced. So that to protect against such a situation, I agree with Senator Choate, there ought to be full disclosure, but the full disclosure must come at the time when you initiate the discussion, because that is what informs his mindset. So I simply included some words which will mean that it would read, is not disclosed by the evidence available at the time of the initiation of such plea discussion.
Madam Chair, if I may address Senator Choate's general inquiry and also the recommendation raised by Senator Sturge. issue of where we treat with disclosure is certain. We must treat with disclosure, and we have in section 11, clause 11 of the bill, which is at page 10. In clause 11.1, we treat with the disclosure before charges are laid, and 11.2, we treat with disclosures after charges are laid. But then there is a circumscribing of disclosure in subclause 3, which again comes from law. And again, the whole administration of justice, interest of justice argument. So disclosure is treated with in section 11. Insofar as the thought is related to evidence and the qualification that it perhaps should be evidence available at the time, I would have thought it perhaps a better fit that we have as wide a description as we do in A, that is an offense that is not disclosed by the evidence, because to limit it to a particular point in time may unwittingly cause us to be out of the system for undue purpose.
No, but Honorable Attorney General, whilst I understand what you're saying, the reason why the time is important is you are going to make an offer of a plea discussion with someone where the evidence against him might be entirely weak. For him to make a viable determination as to whether he should take the bait, so to speak, and engage in those discussions with you, he ought to know what the evidence is available at that point in time. So it has to be the evidence that is available at that point in time, because if there is no evidence available, and as I understand it, proceeding on what you have said with respect to the Section 11 disclosure, I'm not convinced that the Section 11 disclosure is in any event full disclosure.
It isn't, because of because of the application of clause 3, where there is a discretion to withhold all of the evidence in certain circumstances. Well, not all, some of the evidence in certain circumstances.
I see.
So you're right. I had hoped to persuade consideration of clause 8 together with clause 11, as we must read the two sections, two clauses together. And the Honourable Senator Sturge is correct, Madam Chair. There is not a blanket, you must disclose all evidence, particularly because the whole balancing rights and the ability to come out of the plea agreement is definitely there. But then again, when you go to the plea agreement section in section 4, you must put all of these matters before the court, because the court is then seized in the plea agreement of all of the particulars disclosed then as it relates to the plea discussion. So we preferred to maintain the balance as we did. 8 simply saying you shall not enter in certain circumstances. 11 certainly saying that even before, if a plea discussion, if plea discussions are initiated before charges are laid, the prosecutor shall inform the suspect of the allegations against him, and further provide the suspect or his attorney at law with a written summary of the evidence against him, albeit that subclause 3 of 11 does certainly say nothing contained in 1 or 2 is to be construed as requiring the prosecutor to disclose all of the evidence or the names of witnesses or other information, if the prosecutor is reasonably of the view that such information should not be disclosed at that stage, and the suspect or accused is not thereby misled or prejudiced.
I understand, but I have no difficulty with not disclosing the names, because there's good reason having regard to the climate in which we live. But I've looked at the other pieces of legislation, similar pieces of legislation in other jurisdictions, the US, for instance, the UK, and I believe even in Jamaica. Plea discussions and plea agreements and legislation of this type is premised on the basis that there is full disclosure. So I do not believe it could be right for us to be proceeding along the old common law rules of disclosure that gives the prosecutor himself the discretion to withhold, and for him to decide, in his opinion, what is material evidence that should be available to you or not. It should be, as far as possible, you withhold information that protects your informants or your witnesses and so on. But outside of that, or information that would lead to the identification of who the informant or witness is. But outside of that, in keeping with all jurisdictions that proceed on this basis, there's no reason why we should continue to go with the old common law rules of disclosure, and every reason why disclosure should be full, so that when you make a decision to initiate a discussion, you are informed fully, rather than it's partial disclosure and you are in essence in a position where you may make a decision that's not based. Yes. Yes.
Yes.
Senator Sturge, just a second.
Yes.
I think you've, yes.
May I just add to that?
Senator Solomon.
Just to add to that, Attorney General, if you could imagine that you're advising a suspect and the prosecutor is giving the impression that there may be evidence that he is holding but not disclosing, it may lead the suspect or defendant into a false sense of security or insecurity, that there is something else they may have if he doesn't take the agreement. So the flip side is what is not said can lead to fear, inducement, vulnerability. And you can see the threat there.
Senator Choate.
Thank you, Madam Chairman. I am not sure whether the requirement for full disclosure should come in 8 or 11, but there are two important reasons for me thinking that there should be full disclosure. One, this legislation has to be married with the criminal procedure rules, in particular Rule 731, which unfortunately I didn't work with on this occasion, but which deals with disclosure. And on the last occasion, I believe Senator Heath had made a very valuable point to say that if you want to encourage persons to engage in plea bargaining so that the system of justice can move expeditiously, you really need to show them, having regard to our culture, we need to show the suspect or the accused person that his back is close to the wall, if not against the wall, that the prosecution has good, strong evidence against him. Otherwise, he is not going to bite. That's the reality. He will think that perhaps he can stay in the system and play it and have his case thrown out. So it is in the interests of the prosecution, I think, to have full disclosure so that the suspect or the accused person will think, listen, there's no point in me wasting anybody's time in the face of this kind of evidence. And I thought that that was a very powerful point made on that occasion. So I do agree with Senator Sturge that there must be full disclosure. We can't get around it, because if we don't say that in this piece of legislation, then we will be at variance with the test or the requirements set out in the criminal procedure rules, which will just be confusion.
Madam Chair, thank you, honourable senators, for enlarging the thought around this. First of all, I'd like to respond by saying that there is something else in the mix that we need to consider, which is persons testing the waters as to the strength of the prosecution's case. It fits into whether your back is close to the wall or against the wall, true. But in this particular system, we may very well find persons utilizing the system to simply poke holes, or I can't say fishing expedition because you're entitled to full disclosure at stages. The only place where we have a limitation on disclosure is because of the stage at which that disclosure is being made. And that is not at the plea agreement stage before the court. The judge still has to test the level of disclosure, but the disclosure that we're optimizing here is in fact the current disclosure, which is the common law disclosure, the standard in common law. What we're being asked to consider, and usefully so, is putting a statutory provision now to say let's move away from the common law and let's give full disclosure at statute now. And my fear with having two systems of disclosure afoot is that we may unwittingly be opening a system for abusing the process by treating with disclosure differently from the common law position. That's just one of the things in the pot. I did catch Senator Sturge saying that, okay, I can understand the rationale in 11 where you're prescribing against the names of witnesses, but this door of saying that all the evidence supporting the case doesn't necessarily need to be disclosed is really just, in effect, putting into statute what the common law position is.
But that's not what I was saying. I was saying what you can keep out is the names or any evidence that would lead to the accused discovering who the persons are, who the witnesses providing this information are. But I am saying that all of the evidence available at the time ought to be disclosed. And I understand what, my lady, through you, I understand what the Attorney General is saying in terms of two disclosure regimes. But as it stands now, when we deal with absolute immunities and conditional immunities for persons of this nature who are providing information and going to testify, there is full disclosure in that regime. So although we still operate under the common law, when you have an accomplice well known giving evidence, the DPP engages in what is full disclosure. He gives you everything he has. And that is why I'm saying it is necessary in this bill that we, in essence, put in statutory form what already exists with respect to accomplices well known, which is full disclosure.
Attorney General.
Madam Chair, it's a very useful position to consider, but now we're going into the well-known category, which can obviously find immediate similarity to this because we're in the similar circumstance of the DPP engaging via written and express approval under Clause 6 of the permission to enter, etc. But the caution that I really have here in not accepting this submission is that whilst we put a positive obligation with the "you shall" for disclosure, written summary of the evidence and disclose, it may be argued that that disclosure is in fact now an absolute one as opposed to the cautionary one that we come up with in 11. So the intention behind crafting Clause 11 as it fits into our fulminations on the other clause that we're really looking at is to try to cast as careful a wordsmithing over what the common law position is right now, and to achieve the balancing between the two particular pots.
But the common law as it is right now is full disclosure when you are dealing with, because this is an accomplice well known. If you are bargaining with someone, you are bargaining with him, most likely, for him to give evidence against someone, and therefore you are saying this is what we have against you. We are going to use you, we are going to give you a deal, and this is what we'll give you in exchange for X. And if you are going to bargain with that someone, under the common law, the accused persons who are going to be charged on the basis of his evidence are entitled to full disclosure already. So that it's not two different regimes. I'm not saying full disclosure, full stop, applying across the board. We'll still maintain the common law rules of disclosure with respect to everyone else. But when we are dealing with plea discussions, we ought to have full disclosure, and therefore the statute should be on similar terms with the common law.
Honorable Madam Chairman, through you, if I may. Honorable Attorney General, the more I look at this Clause 11, the more I become concerned. If I may take it step by step. We are talking about, I know I'm jumping ahead, but that is because you sort of knit it back to 8.
It is, yes.
We're talking about if plea discussions are initiated before charges. So we're talking about the suspect situation, pre-charge. The prosecutor shall inform the suspect of the allegations against him. Now, all that means in criminal law is that you tell the person that it is alleged that on so-and-so date and so-and-so time, you have reasonable grounds to suspect that he committed whatever offense it is. So those are the allegations as they operate within the context of the criminal law. And then the prosecutor has to give him or his attorney at law a written summary of the evidence against him. Now, disclosure requires the provision of relevant material to someone who is charged, an accused person, which may not be evidence against him. So let's say you have the situation where a witness says that I saw X entering a room, and I saw him touch the window and push the window open and enter the room, and thereafter whatever crime is committed. When they test for fingerprints, there are other fingerprints on the window or whatever that was pushed. Now, that is exculpatory material, which is disclosable in law. And I think in fairness to the suspect, he ought to know that this is in the possession of the state, because otherwise this is a charter for a prosecutor to hide exculpatory evidence. If we say that all you have to give him is a summary of what you have against him, in fact that is to mislead him into an agreement, and that would be improper. So at this stage, quite frankly, I don't know how it can be fixed, but I respectfully ask through you, Madam Chairman, that consideration be given to looking at this whole issue of disclosure fully and thoroughly.
Yeah. Madam Chair, I thank, through you, honourable senators, for their reflections on a very important clause. 8 and 11 are tied inextricably and operate in tandem when they're to be construed. It may be that a disclosure of evidence which favors the defense or injures the prosecution might be the formulation of words, so that we're actually contemplating a written summary of of evidence, including evidence that may favor the defense or injure the prosecution, and then prescribe the circumstances where that may be withheld for proper reasons, as 3 tries to carve out, at least certainly with respect to the names of witnesses. Would you, Madam Chair, just give me a moment to consult with the CPC team?
Sure. But before doing so, Honourable Attorney General, to you, Madam Chair, the formulation just presented by the Attorney General is actually the common law on disclosure. So the common law on disclosure is that you present to the person any evidence that may assist his case or destroy the case for the state. But if you leave it as narrow as that, that's not full disclosure. It also may be apt to mislead, and it doesn't necessarily force the prosecutor to give all that he has, and the prosecutor would be the one under common law who makes the determination as to whether that evidence is capable of undermining his case or assisting the case for the defendant. And that is the problem with common law disclosure. So that is why we are asking for full disclosure, so that we take away from the prosecutor the ability to make that decision.
Mm-hmm. Attorney General, should we stand down clause 8?
Madam Chair, it may be useful if we just fleshed it out just for a little bit.
All right, well then we will take lead of government business. We have the procedural motion to do.
Right.
Yeah. Leader of Government Business.
Thank you, Madam President. Madam President, in accordance with Standing Order 14.5, I beg to move that the Senate continue to sit until the completion of the business at hand, inclusive of the matter on the adjournment.
Honourable Senators, the question is that the Senate continue to sit until the completion of the business at hand, inclusive of the matter on the adjournment. Those in favour say aye. Aye. Those against say no. The ayes have it. The Senate will continue to sit until the completion of the business at hand, including the matter on the adjournment. So we will now resume the committee proceedings.
Madam Chair, could I suggest, or rather could I ask through you, we're on clause 8, and I'm wondering, I'm so sorry. We're on clause 8, and the discussion that we're having in relation to the disclosure of evidence, the extent of evidence to be disclosed really will tie into clause 11. I wonder if honourable members can agree that we can treat with the observations as to the extent of disclosure in 11, because the architecture of the bill is that we treat with prohibitions in 8, and then we make it mandatory to treat with the disclosure of evidence in 11. The two are to run in tandem. Is there anything else that honourable members have that hold them back from making a consideration on clause 8 as it is now?
Madam Chair, with the greatest respect to my honourable colleague, could I suggest that we stand down both 8 and 11 because of the interconnected nature of both, and we go on to 9 and 10 and leave 8 and 11 until we are able to arrive at some consensus. So if I can respectfully suggest, Madam Chair, that we stand down clauses 8 and 11 and we proceed to 9 and 10, and thereafter we could go on to 12.
I have no objections.
So, honourable senators, we will stand down clause 8. When we come to clause 11, I'll stand it down.
Clause 9.
The question is that clause 9 stand part of the bill.
Madam President, if we can perhaps insert the words shall not initiate or engage in a plea discussion with the accused person or suspect in the absence of his attorney at law, so that we between the words not and engage, we put initiate or.
That's agreeable to the government, Madam Chair. After the word not appearing in the third line and before the word engage, insert the words initiate or.
Honorable Senators, the question is that clause 9.
Madam Chair.
Yes.
Madam Chair, through you to the Attorney General. How is it that we envisage that the representation of a suspect or an accused by an attorney at law is going to come to the knowledge of the prosecutor? Because in clause 10,
Senator Ramdeen, you're asking an operational issue at this stage, or is there another amendment? Senator Sturgis put forward an amendment to the clause. Is there something specific you want to raise?
Yeah, what I want to raise is that you have the right to tell the accused he has the right to an attorney. But the flip side of that is that this particular clause requires the prosecutor to do something or not do something based upon the fact that the man has an attorney. But we've put nothing in the law that requires the prosecutor to make any inquiries. So that how is it that we envisage that this is going to work, where the obligation under clause 9
Understood.
is not?
I think it works as a matter of flow, because it's an absolute prescription against engagement, and therefore he would have to initiate a process of asking and then certifying and then recording that. So it'll be a matter of recorded evidence that the prosecutor will say, well, I interviewed you, you don't have, and then he records his steps along the way, because that must come to the attention of the court.
Well, we have a form for the fact, we have a form that engages 9?
Yes.
So I shall now put the question on the amendment. Honorable Senators, the question is that clause 9 be amended as follows by including the words initiate or after the word not. So it will read as follows: when an accused person or suspect is represented by an attorney at law, a prosecutor shall not initiate or engage in a plea discussion with the accused person or suspect in the absence of his attorney at law. Those in favor say aye. Aye. Those against say no. The ayes have it. So the question is that clause 9 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 9 as amended now stands part of the bill.
Clause 10.
The question is that clause 10 stand part of the bill.
Madam Chairman, I'm sorry, if I may. Two things concern me with respect to this particular clause. One, we have someone who is unrepresented, but who may fall into the category of being an accused person, and that accused person may be vulnerable for one reason or the other. Whether it may be some mental disability, whether the person might be a juvenile, that kind of thing. So I don't know how that special category of person may be protected. The second thing is, because they are not referred to, or there is nothing which specifically refers to any added portions to be taken when you're dealing with a vulnerable accused person. The second thing is, where you have an accused person who is unrepresented, having regard to what has been happening in the courts, we see that the mental health, the psychological and psychiatric evaluations of suspects and accused persons ought to be done at the earliest possible opportunity. And certainly, if the person is unrepresented, there ought to be some provision that before he enters into this kind of discussion with a prosecutor, that he should have a psychological and psychiatric evaluation. I'm respectfully proposing that a subsection, however it is worded, that something be included into this clause to provide for the mental health aspect, and also that there be some provision for the protection of vulnerable suspects, vulnerable accused persons like juveniles.
Madam Chair, thank you. The juvenile one, I think I can answer quickly, because the Children's Act provides for child advocates to be present at any point in time during the juvenile's detention. So that one is taken care of by the operation of Chapter 12, Act number 12 of 2012. The issue of competence is a very good one. That is certainly something that we can look at. When we dealt with, I forget which bill it was now, jury, judge only, we did include the concept of competence, a satisfaction as to competence by a simple inclusion there. I'm wondering where that can fit into this, if we're going to consider it.
Or perhaps if I could, Madam Chairman, suggest a prosecutor may only initiate a plea discussion with an accused person who is competent, perhaps, and then I don't know if there may be some explanation of what competence means in the context of the Act.
Or if we were to include that the prosecutor is satisfied that the person is competent.
No.
Requiring a further step.
Well, Madam Chairman, how will the prosecutor know?
Exactly.
You see, and the prosecutor has no power over an accused person. So it really has to be the legislation that gives the power.
How about if we look at C on page 9? Here's where we put in the final caveat. The court has been informed of the matter set out in A and B and approves of the initiation of a plea discussion. We can include competence here. Perhaps. So the court has been informed of the matter set out in A and B and approves and is satisfied that as to the competence of the accused or suspect.
Well, the thing is, it's coming at the end when it should come before, because this is when he's being informed of certain fundamental things having to do with the plea discussion. He is indicating that he wants to represent himself. He's indicating that he's agreeing to plea discussions. To me, the test for competence must be before he does all of those things.
But remember that the court has to approve of the initiation of the plea discussion. So they all come to the court's attention. Ultimately, the safeguard is to make sure that this person was compos mentis, not of any diminished capacity, and that therefore the agreement can't be vitiated by an incompetent circumstance. So the sweep all provision in C was really put in there to make sure that the court, which has the overriding supervision of the initiation of the plea discussion, is satisfied. So I was wondering in the construct of this, in the flow of this, whether we could include the concept of competence in paragraph C.
Honorable Attorney General, through you, Madam Chairman, we can't do that because we will be wasting time. If we have someone who is not competent or who is a vulnerable accused person for whatever reason, we would have the prosecutor going through the steps set out in A and B, going before a court, and then the court having to say, oops, doesn't appear as though this man is competent, or I have reason to believe that he should have a psychiatric or a psychological evaluation. It will be a waste of time.
I was wondering, I seen sub C, that the court approves of the initiation of a plea discussion, but from the way it works, this approval comes after the fact. And is that right?
Yeah, that's what it is.
So, and the thing is, if this person is not competent, I wonder if one can rely on his evidence in any event. So it is time wasting.
So first of all, it's the accused person, so person who has been charged. Person is before the court.
It has to apply to a suspect also, I imagine.
Yeah, so just dealing with 10.
Okay.
So in 10, we specifically deal with an accused person who's unrepresented. We cleave each one of the categories. So in subclause 2, we deal with the suspect, right? So in 10.1, in subclauses A and B, you're before the court, you've been charged, you've been brought before the court, there's a plea discussion to be had, and therefore there's an opportunity to tell the court, look, there's a plea discussion that's about to have, this man is unrepresented, and the court must give its positive positioning. So whether it comes before or after, the point of competence is still there, because we're still going to engage in time, nonetheless, to have a competence issue put before a court. So I don't think that C coming last in the line preempts the fact of, well, sorry, avoids and wasting time, or putting it forward avoids wasting time. Because to get to the court being invited to consider whether a plea discussion should happen, you've got to have material in any event to get there. So I thought if we were going to treat with competence at C, at least insofar as we're dealing with an accused, and not yet treating with suspect, which comes in subclause 2, that we could not disturb the flow as it's set out here. If we come down to subsection 2, the question is whether that is similarly safeguarded.
Madam Chairman, if I may. Honorable Attorney General, the way C, what we are trying to say is that the way subsection C is worded, it does not bear out, or it doesn't have the meaning that you would like it to have.
Yeah.
So
of a prior involvement and competence satisfaction.
If subsection C said that before the steps taken in A and B are engaged upon, the court must satisfy itself that the accused person is competent, and then you can put in the part about approving the initiation of the plea discussion. I'm not a draftsperson, but I think that certainly it must be made clear.
Can I come in here on this point?
May I?
Senator Choate. Sorry, Madam Chair, if I could just clarify. So from a process view, somebody is accused, they're charged, the police are dealing with them, sorry, now a prosecutor approved by the DPP is dealing with them. The issue comes up, look, you're unrepresented. How do you know you're unrepresented? Well, I've told you you have certain rights to be represented. Please sign this form telling me that in fact you don't want that. If we were to then go and say, well, okay, I've got the form saying I don't want to be represented, I now can prove to somebody else that you said you don't want to be represented, and I've given you the positive obligation discharge that I told you that you could be. The next step then ought to be knock on the door of the court and say, hello, here are the forms. This person is about or proposing to enter into a plea discussion, but we need the court's positive approval for this, and the satisfactory markers to cross over would be competence in particular, and the court's approval for that process. Is that correct?
That is so.
Okay. Madam Chair, I'm asking our drafters to try and reformulate the clarity that should be poured into subparagraph C to capture that in the meanwhile.
Senator Mahabir wanted to raise
Yes, thank you, Madam Chair. I think this is a critical issue. I raised it earlier with respect to an individual, an accused person who only has a justice of the peace to assist him while he enters into this agreement. And I'll raise it again. You see, it is important that we satisfy ourselves that the individual who chooses to be unrepresented has the mental capacity to make that decision. And so I would like, Senator Choate would like to see this up front, so that under A, I would recommend Attorney General, the 10A, the accused has been subject to a psychiatric evaluation. So it would read, the prosecutor shall not initiate a plea discussion with an accused person who is not represented by an attorney at law unless A, the accused has been subject to a psychiatric evaluation. That would give me the comfort that in the absence of an attorney, at least there is another line of defense for him. He has been evaluated by the relevant specialists, and so we know for sure that this accused person or this suspect has the mental capacity to make the decision that he does not wish to be represented by an attorney. So I put it for your consideration.
So
the accused has been subject to a psychiatric evaluation.
We're going a step further. We're asking that to be done by a judicial officer. Okay. So we're on the same page, but we're putting it in the sanitizing light of a court's discretion and consideration. So that's what we're looking at in making clear the language to see. The flow of it, to get to the point of saying somebody wants to be represented or not, still has to be traversed. And the way that you tell a court somebody doesn't want to be represented is to certify in writing. I told them they have a right. They said they don't want to do this. They've signed this, the justice of the peace. You take it before the court. Court says, okay, I have evidence that somebody's saying they don't want to be represented. They then ask the person, do you want to be represented? And then they go through the steps on competence to make sure this person has the capacity or is not under any other disturbance to fetter the consent.
Senator Mark?
Yes, Madam Chair. This entire clause, there are some areas that are scary. And I want to bring to your attention those areas that have me a bit concerned. And through you, I would like to ask the Attorney General, in clause 10, when we go to subsection B, Madam Chair, there's Roman 2. It reads, he agrees to the plea discussions being recorded. But there's no provision that tells me, Madam Chair, how is this recording going to be facilitated? Is it going to be videoed? Is it going to be in writing? Is it going to be both? And remember, this is coming against the background where we are being told in clause 10, that the person has voluntarily said they do not want to represent themselves, or they want to represent themselves. Well, I agree with Senator Mahabir. That person needs psychiatric help. Because I cannot see a sane person saying that. That person is mad. Or needs psychiatric aid, Madam. And Madam Chair, I would also like to ask the Attorney General to have a provision in this section specifically dealing with the whole issue of legal aid for those persons who can't afford a lawyer. That must be included here. I'm asking the Attorney General to consider this. Well, and Madam Chair, when we go to the forms, you would see in clause 10, B, it talks about form 1. And then when we go to clause 2, B, it talks about form 1A. I would like you to join me and look at form 1 and what form 1 says, and we believe ought to be expanded. Madam Chair, and through you to the Attorney General, where in this form that this person who says he wants to represent himself in plea discussions, there should be a provision in this Form 1 and Form 1A indicating that, I don't know, the people will deal with the language, that person, Madam Chair, hasn't been threatened. There must be a provision here that indicates that before that person signs, he knows that there's a provision that talks about that. Is that there?
Of my free will.
Of his own free will. And offered and...
But your point is noted, Senator Mark, and the Attorney General, I'm sure, will address it. Right?
Madam President, I just, Madam Chair, sorry.
Could I just inch my way forward? Address some of the proposals that are coming, Madam Chair, if that's okay. Sorry, Senator Stooge. We're proposing to include language of this type, just for general consideration. So this is to take care of the lack of full description in subclause C, which will have to be repeated into subclause 2 when we come to that. So we're proposing that the court, 1, has been informed of the matters set out in paragraph A and B. 2, is satisfied that the accused is competent to enter into plea discussions and conclude a plea agreement. And 3, approves of the initiation of a plea discussion. So that the court would have to traverse all of those elements for an unrepresented person. We can take that, substitute paragraph C, which is on page 9, B, just in the middle of the page, substitute it with those words, and then look for a similar reflection into subclause 2. Relative to the observation by Senator Mark of the person not having been threatened or coerced, the form in fact says of my own free will and volition, which actually puts that in there. We're looking at including in subclause 1, right, in reference to the recommendation in that subclause 10, also include the reference to if you can't afford that there's legal aid. That's specifically treated within subclause 12, sorry, in clause 12, upon the first appearance of the accused person before a court, whether the accused is represented by an attorney at law or not, the court shall advise right to enter into plea discussion if the person cannot afford legal aid, right to enter into plea discussion with prosecutor, etc. So that's taken care of in clause 12 specifically, because that's when your first come, the court tells you all of these things. It therefore leaves only open. See, it therefore only leaves open now the treatment of suspect in subclause 2, but I did truncate Senator Sturge at this moment, Madam Chair. I don't know if this may be an appropriate time for him to rejoin.
Yes,
Senator Sturge.
yes, I was wondering, and it may very well deal with Senator Mahabia's issue. After the words, the opening words in section 10.1, not represented by an attorney at law, perhaps we could insert a clause, unless the prosecutor first notifies the legal aid and advisory authority, and the authority provides a duty counsel for such accused person. So that basically, we are not at the stage where he's first brought to court. We are,
yes,
we are even before that. So before you initiate the plea discussion, the prosecutor who stands to benefit by this discussion has to contact, since he's unrepresented, contact the legal aid and advisory authority, and the authority provides a duty counsel.
So the Legal Aid Advice Act, actually, I've just pulled it up. So section 4A of that provides for duty counsel. This is the amendments we put in 2012. The director shall prepare and maintain panels of attorneys at law, known as duty counsel, who are willing to provide legal representation for a minor as soon as possible after the minor is detained on suspicion of having committed an offense. Provide legal representation for persons detained on suspicion of having committed a capital offense or such other indictable offense as the minister may by order, subject to negative resolution of Parliament, specify. So the Duty Council, we have the opportunity in 4A of the Legal Aid Act to traverse the matters described, and we can probably enter into an amendment of that order to match up with this, and we could perhaps give that undertaking. Would that help us at all in that regard?
Yes.
Yes? Madam Chair, so what we would specifically propose is that the government look at the order produced under the Legal Aid, the Legal Aid Act, particularly Section 4, and then we would include the matters for which plea discussions may be contemplated and unrepresented accused. So we can specifically treat with that to make sure that Duty Council are available as a necessary safeguard. I thank Senator Sturge for raising that.
And Madam Chair, before you proceed, may I just indulge you again for a few seconds? I did ask the Attorney General to clarify when we talked about being recorded, in what form? Is it going to be video recording, Madam, or writing, or both? I would like him to clear the air on that for me. And as I'm on this point, Madam Chair, may I ask you?
Senator Mark has asked about being recorded on page 9. What form of recording is that?
Is it going to be video, recording, and writing, or both?
The truth is that we had not condescended to say either one, really because of technology being specific. The intention, as we are in fact outfitting right now, we've started already, we have 14 video recording suites, and they are all being utilized as a mandatory rule for recording. So the intention is that they're video recorded, but I don't know the functionality of these things on a continuous basis, so we had opted for recording. The point is that there should be, I can appreciate the argument that even an audio recording can be doctored, so too can a video recording, but we had not specified specifically video or not, but it will certainly be recorded. That's one of these safeguards specifically for this person who's a suspect and not yet before the court.
I'm sorry, Madam Chairman, but are we looking at
page 10, Roman 2, top?
Page 10? No, 9?
It's clause 10. It's clause 10, 1B.
Right, so what we are looking at there is someone...
I see, I was looking at the other one. Apologies, sorry.
Yeah, someone who has already been charged.
Yeah.
So I think the mischief that Santa Mark is trying to address is where you have someone who still may not have spoken to an attorney at law, is being recorded as making any admissions of guilt, and that being able to be used against him at any time thereafter. If he enters into the plea discussion, or if he says at a later stage he doesn't wish to plead guilty. So I'm thinking that perhaps how we could address that issue is that we can say, one, he desires to represent himself, and two, he wishes to engage in plea discussions, full stop. So you take out the whole possible prejudice, possible self-incrimination, possible breach of constitutional rights, by simply saying that the person has indicated that he wishes to engage in plea discussions.
Right? But the right of self-incrimination is actually a very important point. So what she's saying is the accused person has been informed by that would be very agreeable.
Thank you.
Perhaps, would you mind assisting us with the language to Roman 2 just one more time?
and he agrees.
Where are
Sorry,
you?
I beg your pardon,
Yeah.
Madam Chairman. We are at
Page 9B.
page 9, 10B2. And 2 would read, we would delete the words agrees to the plea discussions being recorded, and we would instead have he agrees to enter, or he wishes to enter into plea discussions. So we take off everything after he, and you say he wishes to enter into plea discussions.
I'm just worried about the word wishes. It seems,
I know.
Would agree be any different?
No, because you see, when you agree to something, you're giving away a right. You know, when you agree, you must make sure that the person is in a position to agree.
And
He has indicated his
even,
willingness to enter into plea discussions.
would it help us that C as redrafted is all subject to the court's approval?
No, because you see, Honorable Attorney General, 2,
We could use desires, as we have in Roman 1.
yes.
Yes?
He desires to enter into plea discussions.
Madam Chair, my only question here, the reason, the rationale for including the recording was as a safeguard to both parties, the victim and, the accused and the prosecution, to make sure that nothing untoward can be alleged. Senator Ramlin had raised very usefully the whole reliance upon confessions, etc. So I'm wondering, even though the right and the reflection on self-incrimination may arise, insofar as it's subjugated to the due process of the court, because the court is specifically the one to, all you're doing is you're indicating your position, then you've got to go to court, the court then establishes your competence. Do you think that we would lose anything by having that potential safeguard there?
Madam Chairman, to the Honorable Attorney General, certainly we would. We would be taking away the accused person's right to silence, which is constitutionally protected, because he would be giving an indication with respect to his liability for the criminal offense for which he is before the court. He would also be giving an indication which derogates from his right to incriminate himself. Now, my understanding is, as far as possible, we want to keep within the constitutional remit. And I don't see how we are doing that.
Accepted, yeah. Okay. Yes, Madam Chair?
Can I just add? Madam Chair? Attorney General, if you go to 10(1)(a), and you look at Roman 1, right? Could you not incorporate the point that senior counsel is advancing, Senator Choate, there, as well as the right against self-incrimination?
Well,
because you remember,
that's a constitutional right, so there's an expression of that already in the Constitution as the supreme law.
yeah, but you wouldn't want that, because you need to inform. Remember, other people not too enlightened as us.
Well,
so you need to inform these people.
Let's also put on, it's important to bear in mind that clause 33 specifically treats with evidence. Evidence of the following matters is not admissible in civil or criminal proceedings against the accused person who entered into a plea agreement or is a party to a plea discussion or to plea discussions. an offer to enter into a plea agreement or a statement made in connection, a statement made during plea discussions or a plea agreement hearing, a plea agreement or guilty plea, which is later withdrawn. So this is the safeguard against any potential adverse effect to your right against self-incrimination.
No, AG, I don't think that that will take care of the mischief. This is about evidence.
But I do agree with Senator Choate that we can remove the recording aspect from Roman 2.
No, I think the point that Senator Mark is making, Senator Choate's point is on a substantive issue. The point that Senator Mark is making is that when an accused person, before an accused person enters into the purpose that you're having Roman numeral 1 in 10.1a is because the purpose of this is for unrepresented.
I catch you now. So putting forward the express obligation to inform of your right against self-incrimination.
Yes,
yeah, we could do that. Yes.
And may I just say one more thing, Madam Chair? With the leave of the Honorable Attorney General, 10.1a, Roman 2, on page 9 of the bill I have here. May I read it, Madam Chair? That he may elect to have a third party of his choice present during the plea discussion. I want to just make a slight amendment for the consideration of the Attorney General. After the word present, I want to add or include before entering any plea discussion and delete the words during the. You following, Madam Chair? So we are saying that the person may elect to have a third party of his choice present during, right, the plea discussion. We would like to have before entering any plea discussion.
And during.
Yep.
And during.
And
during. You want them during.
So so it's the prosecutor's obligation.
Right.
That we're spelling out here. The prosecutor has informed the suspect. Right to be represented by an attorney at law. That he may elect to have a third party of his choice present. And I think we would have to add in the right against self-incrimination here as well. So,
and a legally appointed attorney? Legal aid?
Yes.
If you can't afford an attorney.
But 12, so 12 is at first hearing, so we can do the legal aid.
And AG, also in terms of juveniles and mentally handicapped persons, you need some sort of protection, social worker or guardian.
Okay.
Through you, Chair. Sorry. Through you, Madam Chair. The safeguards for the vulnerable suspects and accused.
Just for clarity, Madam Chair, through you, I'm proposing that we include the following positive obligations in the various places where we treat accused and suspect. The right to be presumed innocent, the right against self-incrimination, and the legal aid position.
Yes.
So that we include that into 10.1a, Roman 1 onward, that we include those positive obligations, that we, at subclause B, that we would change the wording of Roman 2 to say instead, he desires to enter into plea discussions, and delete the words there, following up to the word and then in subsection 2A, with respect to suspect, that we would include the similar expression of rights that the prosecutor must inform about. So that would be legal aid, presumed innocent, legal aid, right against self-incrimination.
Yeah.
Where we are getting to now is what Senator Mark and Senator Daniel Solomon both raised, that he may elect to have a third party of his choice present during plea discussions.
Before and during.
We can also, what we wanted to put there was the fact that the person knew that that person could be there for the entire time. Nobody could put them out, etc. Right. May I just inquire through you, Madam Chair, what the further mischief here is? Because this is where the prosecutor tells the suspect what he's entitled to. It isn't the fact of it happening just yet. I'm trying to figure out the language that was suggested about the agreement.
Oh, yeah. Yeah. What I was saying, AJ, is that how it was reading here is that the individual in question, if he doesn't have an attorney, he could elect to have a third party of his choice present. And how it was reading is that this could take place during the plea discussions. And I wanted to make sure that the language is, very, very clear, that the person would be able to be entitled to this particular third party before entering into any plea discussions. So he must know that it is not during that period he is going to be having a third party being present. He must have that third party being present before he enters into any plea discussions.
Bear in mind,
that's the point I was trying to make here.
Bear in mind that what we're doing is we're saying, because these persons are unrepresented, they have to go to the court to get permission. So for the accused, you go to court. The problem with the suspect is that the suspect is not yet charged. So I catch your point further. So you're saying that even before a discussion is entered, that a third party could be there. Okay, I understand.
If I may, Honorable AG, through you, Madam Chair, is that when you're dealing with vulnerable suspects in particular, they would require, for instance, a juvenile would require some sort of parent or guardian to be there prior to plea discussions being engaged.
But that's in the Children's Act for sure.
Yeah, and we need to make sure that also within the mental health guidelines as well, that they may not be initially discovered as having some sort of mental illness, may have a keen eagerness to talk and please the prosecutor or the police. Those safeguards need to be put in place, and I think Senator Choate had rightfully mentioned that previously. So I just want to be aware of that. Those rights will need to be regurgitated here as well. Thanks.
Attorney General, should we stand down?
Yes, please, Madam Chair. I'm asking my team to come up with the appropriate language to treat with 10. Just one moment, please.
Attorney General, I think we should stand down, close.
Thank you,
close
Madam
10.
Chair.
Yeah,
The drafters were just asking for instructions
Sure.
on the positions.
sure. So clause 10 is stood down.
Clause 11.
I need to call it first.
Clause 11.
The question is that clause 11 stand part of the bill. Honorable Senators, according to the earlier deliberations, we will stand down clause 11.
Clause 12.
The question is that clause 12 stand part of the bill. Dealing to 12 now. Yeah. The question is that clause 12 now stand part of the bill. Those in favor say aye. Aye. Any against? The ayes have it. Clause 12 now stand part of the bill.
Clause 13.
The question is that clause 13 stand part of the bill.
Madam Chairman, if I may, 13.1, may I respectfully propose that the words "has the right to" are excised and replaced by every victim may, by the word may.
Attorney General.
Agreed.
Honorable Senators, the question is that clause 13 be amended as follows, that 13.1, the words "has the right" be deleted and substituted with the word "may."
And it'll be in subclause 2 as well.
So it will read, every victim may provide a victim impact statement. And then in subclause 13, subclause 2,
After the word victim,
after the word victim,
delete of his right.
right, delete of the words "of his right."
So before plea discussion is concluded, the prosecutor shall
Madam
inform the
Chairman,
victim
may I
that he
suggest
may
that he
provide. That he may provide.
In subclause 2, 13, subclause 2, delete the word "shall" and substitute the word "may."
No. Before a plea discussion is concluded, the prosecutor shall inform the victim
Yes.
that he may provide. So deleting the words "of his right to."
Correct. Sorry, my apologies.
Madam Chair, I need to come in.
Let me just get it, please. Before plea discussion is concluded, the prosecutor shall inform the victim that he may provide. Correct?
Yes, ma'am.
Yeah. That he may provide a victim impact statement. Yes.
Madam President, I rather like how it was stated in 13. This is the first piece of legislation that I am seeing which really puts victims at the center of the law. And I thought that a victim who has the right may not necessarily exercise the right.
So may I put it this way? May and has the right to effectively is the same thing.
If he has the right, it shows that the victim has rights too, you know.
But Senator Choate's position is, in fact, I think preferable in terms of the caution, because then you're talking about quote unquote a statutory right versus a right per se as a constitutional right.
So, Honorable Senators, the question is that clause 13 be amended as follows. 13.1 will now read, every victim may provide a victim impact statement explaining the physical or emotional harm, financial loss, or other impact that the offense has had on the victim. Clause 13.2, before plea discussion is concluded, the prosecutor shall inform the victim that he may provide a victim impact statement and of the restrictions specified in section 14 with respect to the content of the victim impact statement. All in favor say aye.
Aye.
Any against? So the question is that clause 13 as amended now stand part of the bill. Those in favor say aye.
Madam Chairman,
Senator Choate. Yes?
I don't mean to I think, I'm sorry, I just got distracted. It's C, 13.3C.
The victim's right to read, that he may read.
Yes.
Apologies.
And
Just a
no,
second,
it has,
please.
So at C, it should read that the victim may read.
I don't know. Ask him.
The victim, so the victim is informed of, that's an
Yeah.
odd construction. That's a difficult one to recast. So, may I ask through you, Madam Chair, whether, insofar as it's discretionary with me, whether the use of the language is still as offensive, even though it says a right to read, because you may elect or not elect. Yep, or we can amend this way, Madam Chair. If you look to the chapeau, that's in subclause 3, we could delete the word of and now say a of. We put in, instead of the word the, so now we'd insert the word of. So we'd insert the word of the. Of in A, of in B, and that. So it would go, the victim is informed, dash, yeah, of the substance and reasons, so that'll read there, of the date of the plea agreement, that'll read as it goes, that in C, that he may read. So delete the victim's right, 2. So, subclause 3, delete the word of in the chapeau before the dash. Insert in subparagraph A before the word word of at the beginning of the paragraph, subparagraph. Similarly, insert in subparagraph B the word of before the word the at the beginning of the subparagraph. In subclause C, delete the words at the beginning of the paragraph, the victim's right to, and insert instead that he may. Would that work, Senator Choate? Through you, Madam Chair.
Yes. So may I put the question now, please?
Madam Chair, if I may, Honorable Attorney General, 13.4.
Sorry, in C, Madam Chair, we need to delete in the second line after the word the court or, we need to delete that word to.
Yeah.
Okay, sorry.
Senator Solomon.
Thank you, Madam Chair. If I may, Honorable Attorney General, Section 4, subsection 4, sorry. If a victim elects not to give a victim impact statement, the court at the plea agreement hearing shall not draw any inference that the offense did not result in harm to the victim. Are we not here also in the danger of usurping the court's jurisdiction and the court's power to make decisions? Also, that clause appears to me to be somewhat superfluous.
I wonder whether the word shall will be read as may when interpreted by the court.
Madam Chair, I don't know if that we should be interfering with the court's power and discretion. We here in Parliament to make inferences and not to make inferences by victim statements that are or not apparent.
Madam Chair, I'm torn. There's persuasion in the argument that some may interfere with the court's discretion, but really there is also prudence in stating expressly that you don't want to necessarily have someone form an adverse inference that you've elected not to do something.
I think, Adri, that we should have some as difficult as it might be, I think we should have some confidence in the judges that administer these criminal trials.
Senator Ramdeen, you can rephrase, put that another way, please.
AGI, trust the judges. This is a matter of admissibility in relation to evidence that is before the court. And I think the courts are competent to deal with a matter like this, especially something as fundamental as this, because this is simply a matter of whether you're admitting evidence that is prejudicial to the accused. And I don't think any court needs to be told in a statute as to how to exercise that inference.
Sure. Appreciate your views. I didn't quite catch it in a pejorative sense. May I, through you, Madam Chair, invite my colleague, Senator Choate, for any reflections on the submission that subparagraph 4 may intrude upon judicial discretion and can be excluded?
Madam Chairman, quite frankly, I have no view on the matter.
It's a safe view, Senator Choate.
Through you, Madam Chair, Honorable Attorney General, I don't know if this would...
Just 1 second. The Attorney General is...
I don't mind listening because it can allow me to think as well. Through you, Madam Chair.
Yes, Senator Solomon.
The fact that it's not only the fact that the victim did not give a victim impact statement, it's also that it didn't result in any harm to the victim. And that's going further. And that's actually inferring that the fact that the victim didn't have any harm come to him or her, that the court shall not draw on any inference. And that in itself is something I think the court is quite competent to do on its own. It really should be deleted in my humble submission.
Madam Chair, I endorse that position. I see no benefit in having clause 4 there.
Madam Chair, if I could just put onto the record, I welcome the submissions of my learned colleagues. The rationale for including this was borrowed from the Jamaican experience, their legislation, which actually provides for this positively. And really it was to take into account the experience in other parts of the Commonwealth, Canada, etc., where it also appears. But really it was because of the novelty of the law, because we're introducing for the first time this whole concept of a victim impact statement. And therefore, even though there's a statement that appears on the face of it to interrupt judicial discretion, I'm wondering if really we should err on the side of caution. Senator Ramdeen has made a very useful observation that it's a matter of evidence and that the court ultimately determines evidence. So I'm quite frankly torn, Madam Chair.
But we need to
have a decision.
A decision has to be made.
Just give me a moment.
Is it that I shall stand it down?
I just require 30 seconds.
Sure.
AG, just consider also that I know that we have this particular aspect of having a victim impact statement, though this might be the first statutory introduction of it into our law. We have victim impact statements in the criminal law already. So the courts, without this.
Madam Chair, we're prepared to delete it.
All right. Much obliged.
Honourable Senators, I will now put clause 13 to the chamber. The question is that clause 13 be amended as follows. 13.1, every victim may provide a victim impact statement explaining the physical or emotional harm, financial loss, or other impact that the offence has had on the victim. The words "has the right" are being deleted and substituted with "may." 13.2, before a plea discussion is concluded, the prosecutor shall inform the victim that he may provide a victim impact statement. So the words "of his right to" are deleted and substituted with the words "that he may." Sub 13 sub 3, is amended as follows. A prosecutor who concludes a plea agreement with an accused person or a suspect shall ensure that the victim is informed, A, of the substance and reasons, B, of the date of the plea agreement, C, that he may read his victim impact statement in court, or have his victim impact statement read. And subclause 4 is deleted. Those in favor say aye. Aye. Those against say no. Say aye.
Madam Chair, we just, of course, change the marginal reference to say victim impact statement, deleting victim's right to make A. It would just say victim impact statement.
Honorable Senators, those in favor say aye.
Aye.
Those against say no. The ayes have it. Clause 13 as amended now stands part of the bill.
Clause 14.
The question is that clause 14 stands part of the bill. Senator Ramdeen, you have proposed and circulated an amendment.
AG, I had, for the same reasons that for the same reasons that I advanced in relation to deleting clause 13 subsection 4 was the basis upon which I didn't see it necessary for us to provide for the victim impact statement, not including A, B, and C. In any event, the court before whom this evidence is going to be adduced for whatever purpose will have an overriding discretion to delete any evidence that is more prejudicial than probative under the general principles, and therefore that is the basis upon which I had advanced that these are really matters that we should leave to the discretion of the court and not micromanage that process.
I'm sorry, Madam Chairman. I think that this clause appears in legislation in almost all the jurisdictions that I can think about, that I've read about, because it involves the protection of the person who has pleaded guilty at the sentencing stage from having the course of justice in a sense perverted or turned aside or misdirected by the inclusion of these facts, by the legislature saying that these things shall not be included in the victim impact statement ensures that they will not be included, and there will not be a weighing up of whether they should be or not, with reasons having to be given for whether they should be included, and that being a possible ground of appeal and all kinds of things. So I think that this clause is in accordance with similar legislation in other territories, and I support it.
Attorney General.
I wholeheartedly agree with this submission. It's the exact view that we hold. Just to avoid difficulties with the administration of justice, statutorily setting out what the prohibitions look like, to avoid the prosecutor falling into difficulty as they prepare the statements and have supervisory effect.
Yeah.
Honourable Senator.
Madam Chair, I need to come in here because I support Senator Ramdeen's point on this. Again, this is for the first time I am seeing victims being included in the law. And when I see 14A, a restatement of the facts of the offense, you see, I'm just wondering if a victim who has been raped, for example, cannot restate some of the facts, what kind of impact statement is going to be made? So are we actually determining what kind of trauma and pain the victim has suffered if the victim holds the view that in the event of an armed robbery or a rape, you cannot restate some of the facts of the case? I would think that the victim impact statement should be left up to the victim as far as is possible. It's a victim impact statement. It's not a statement from anybody else. It's the first time the victim is being given a voice. And that we would like the victim impact statement to really capture in totality the impact on the well-being and the welfare of the victim, to give a more balanced view of what the situation is like and what kind of decision the court will make. So I would raise for your consideration the removal of at least A, because there has to be some restatement of the facts of the case. If a gun is put to your head, that's a fact of the case. If any heinous thing is done to you, it's a restatement of the facts of the case. To say that it shall not include a restatement of the facts, it means it shall not include a restatement of all facts.
Okay, so Senator...
I would recommend the removal of 14A.
Sure.
Madam Chairman, if I may.
Yes, Senator.
The crucial word here is impact. So you do not need to restate the evidence to say what the offense, what impact the offense had on you. You may speak about your trauma, you may speak about medical bills, you may speak about disability as a result, that kind of thing. That is the purpose of a victim impact statement. We cannot in this piece of legislation elevate a victim's or the facility that is being given to a victim in this piece of legislation. We cannot elevate it to equate with the due process constitutional rights which an accused person has under the Constitution. If we do that, then we are opening a can of worms.
AG, just before you answer, I want to ask this. When this provision is put into the law, how is the victim going to know what he has to put in and leave out of the victim impact statement?
Because the prosecutor supervises the process. So it is through the prosecutorial arm, and to answer Senator Mahabir and to adopt the submissions of Senator Choate, the case law is also pellucidly clear on this. R.V. Gabriel, being the leading case on it, really speaks to this. There's been a lot of judicial consideration and development over the years as to what a victim impact statement does, stress being on impact, having adopted everything that Senator Choate has said as well.
Honourable Senators, the question is that clause 14 now stand part of the bill. Those in favour say aye.
Aye.
Any against? The ayes have it. Clause 14 now stands part of the bill.
Clause 15.
The question is that clause 15 stand part of the bill.
Madam President?
Yes.
Yeah, 15B. It says that a relative of the victim may provide the statement if the victim is ill or otherwise incapacitated. I would like for the Attorney General to indicate to me whether otherwise incapacitated includes a victim who has been traumatized and is terrified and is suffering some kind of post-traumatic stress syndrome, or does otherwise incapacitated simply means that he is ill and unable to come to the place where he has to make the statement. Because if not, I would like to include a traumatized victim in there who has elected not to give a statement and a relative may give it on his or her behalf.
Senator Ramkisoon, just a minute, AG. Senator Ramkisoon, you wanted to raise something?
Yes, thank you, Madam Chair. In relation to this clause, we're asking for relatives to be invited to make an impact statement. And how we define it, and after much discussions on clause 14, I'm not exactly sure how any relative, because we opened up the arm of relative to any other person or any appropriate person. So I want to know, how is this really intending to play as a suitable impact statement? I know it's a little different to what Senator Mahabir has raised.
Attorney General.
Sure. To answer Senator Mahabir, otherwise incapacitated is intended to be as wide as possible to encapsulate everything, lest we unduly prescribe it by language which cuts down the effect of it. Because obviously a court is going to have to consider the appropriateness of the person who's now coming forward to say, I am a relative within the definition of Section 2, Clause 2 of the bill, and you ought to consider me, because that's why we put in the word appropriate. To answer Senator Ramkisoon, yes, we have opened it. It is ultimately going to be for a court to decide whether this is an appropriate person to come forward in all of the circumstances. And the intention is really to facilitate the voice of a victim where that voice may have been silenced or unavailable. So there must be a sufficient nexus in the court's mind. This is not something which is without judicial precedent. There's judicial precedent for this in a number of jurisdictions, which we can lean to for interpretation as to the appropriateness.
Madam Chair, through you, after looking at what is expected in the victim impact statement, I'm not really seeing the need or how, I know you said it's based on the courts, but how this would really be done or achieved by a relative. Because we're asking for physical or emotional harm, financial loss, or other impacts that the offense has on the victim.
It can be treated with, for example, by a parent speaking to the defect on a child speaking to the defect on a parent.
And that's in clause 16.
Yeah, but what we're speaking here is that it may be made by a relative. So we're providing in 15 the springboard from which the relative may act. So this is the locus. You're creating the capacity for them, the jurisdiction for them to enter the court process. They borrow from the definition in section 2. This is, if we didn't have this, they wouldn't have what we call in law locus. They don't have the position to come to the court.
Okay.
So the question is that clause 15 now stand part of the bill. All in favor say aye.
Aye.
Any against say no. The ayes have it. Clause 15 now stands part of the bill.
Clause 16.
The question is that clause 16 stand part of the bill. Senator Ramkissoon.
Thank you, Madam Chair. Through you, I raised during my debate about the child as it defined in the Children's Act as 18 years and under. Why did we go with 14 years? And, well, it repeats a A and B if we want to go to one age.
Specifically to treat with the categorization of how evidence is treated within those age categories, which is also treated within the Children's Act. So in the Children's Act, we speak to the age categories for the mind of the child in these very circumstances. So it's to make it pari material, equal material with the Children's Act.
I looked at the Children's Act and I didn't see 14 years pull out, but I did see in the Bail Act where we had, I know we didn't debate that yet, but the existing one has 14 years. A child is defined as 14 years. I know we have removed that and we're going to child is defined as
now we're treating with evidence.
18 years.
Yeah, we're treating with the rules of evidence in relation to age. And this is how our law treats the evidence. Not the fact that you're a child, but the categories of ages. And you'll see it as well when we treat with the other legislation, not on all fours, but when you're looking to what was called YODA, the Young Offenders Detention Act, now the child rehabilitation legislation, it's treated with similarly where we categorize.
So, Honourable Senators, the question is that clause 16 now stand part of the bill. Those in favour say aye.
Aye.
Any against? Say no. The ayes have it. Clause 16 now stand part of the bill.
Clause 17.
Question is that clause 17 stand part of the bill. The question is that clause 17 now stand part of the bill. Those in favour say aye.
Aye.
Any against? The ayes have it. Clause 17 now stand part of the bill.
Clause 18.
The question is that clause 18 stand part of the bill. Senator Ramlin, you circulated an amendment.
I had circulated an amendment that asked that those first two subsections, 1 and 2, be deleted. But having regard to this position that you've taken and the committee has taken with respect to 14, then I think that I will withdraw that proposed amendment.
Thank you.
Senator Choate.
Madam Chairman, thank you. What I am proposing is that certain words be added to subsection 4, that after the word so, that the words and in any event, comma, before it is filed with the court, full stop. And I'm asking for that addition to ensure that before the documents are filed with the court, and before the convict is required to make his plea in mitigation or whatever, he has an idea of what the victim impact statement contains, so that when he comes before the court, no time will be wasted by having him asking for time to consider the victim impact statement, to get the victim there, and all of those things. If he has the material beforehand, then expedition will be paramount.
May I?
Yes.
Very strong suggestion in line with some of the work that we've been doing in other parts of the law in this Senate. I'm just wondering about the consequence where it couldn't be done. That is the caveat to the rule. So as soon as is reasonably practicable, but once we qualify it and in any event before it is filed with the court, the question is whether we're going to be tripping upon a lockout because it wasn't done.
Well, if it wasn't done, then it wouldn't be filed with the court, and this wouldn't arise.
No, so in this circumstance where we can't find the person, etc., because after receiving victim impact statement, the prosecutor shall serve the victim impact statement on the accused person or his attorney at law as soon as. I see. So the fact that they are participating in a process means that they are in contact with each other, so it would make it reasonable to assume that the service could happen. Just give me a moment. Madam Chair, so I was looking at the process flow of Clause 18, if Senator Choate will help me with this through you. 18.1, prosecutors shall ensure you comply with Section 14. 2, a victim impact statement, if it contains material not permitted, redact. Victim impact statement in 3 shall be filed with the court at the time of filing the plea agreement. And then we go to 4, which says, after receiving the victim impact statement, the prosecutor shall serve the victim impact statement on the accused or his person at law as soon as is reasonably practicable. The language being cautioned here is that you must do so in any event before you file it with the court.
Yes, because I could see how the thinking went, because as lawyers we are used to filing and then serving. But I'm just saying that in this case we may be defeating the purpose that we want from this aspect of the law. So I'm respectfully suggesting that we qualify it.
Yes. Madam Chair, I'd be happy to agree to the amendment.
Senators, the question is that Clause 18 be amended as follows. In 18 sub 4, by including the words after so, removing the full stop and continue, and in any event before it is filed with the court. Those in favor say aye. Those in favor say aye. Aye. Any against say no. The ayes have it. Clause 18 as amended now stands part of the bill. No, the question is that clause Clause 18 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 18 as amended now stands part of the bill. Honourable Senators, at this stage, we will take a break. I will suspend for 15 minutes. So we will resume at 9:15.
This is the Parliament Channel and Parliament Radio 105.5 FM.
Edward Hart, better known as Eddie Hart, had a humble beginning. His early years were spent at the Tacarigua Orphanage, and only a stone's throw across the road from the orphanage is the ground that now proudly bears his name, the home of the Eddie Hart Football League. The league was formed to provide a valuable alternative and outlet for the youths who were getting into antisocial activities. Because of this valuable contribution to society, coupled with his popularity, Eddie was called upon to represent the Tunapuna constituency in Parliament.
Well, in 1991, while the PNM was in opposition, they were getting ready for the general elections. And something went wrong with the then candidate who they had for Tunapuna, Mr. Derek Bong, and I was called into the arena 3 weeks prior to the election. At that time, they had 2 people contesting other than the PNM candidate. You had one from the NAR, Mr. Emmanuel Hussain, who was the incumbent, he was the Minister of Health at that time. And then you had a young man, Colin Seeley, contesting for the UNC. So it was a 3-way fight. And as fate had it, we won the seat in 1991. And then we went on again. In 1995 again, I was the candidate, and we came up against Mr. Hector McLean. Mr. McLean was a young, bright lawyer coming out of Tunapuna, and he held many portfolios in the PNM government before he fell out with the PNM. And he was out for a while, out of the politics. And he came back on a UNC ticket in 1995, and again we won the seat. And it was very surprising that Mr. McLean was sworn in as the Speaker of the House of Representatives, because the UNC won the election on that occasion. They formed the government. And then we went on to 2000, and then we met Mr. Movin Assam. Mr. Assam won the seat. There's a lot of controversy about voting pattern, etc., etc. A lot of controversy because Tunapuna is always a hotly contested seat, very close, always a marginal, so from the time I came in. And then in 9 months' time, the UNC government collapsed. And again, I contested on a PNM ticket, and we won. That was the most breathtaking, because that is the famous or infamous 1818 that people would always remember. It was a very nail-biting finish. When the votes were being counted, the UNC had 18 seats and the PNM had 17. And the last seat to come in was the Tunapuna seat. All eyes were focused on Tunapuna. And with the help of God and the party and the supporters, we won this seat and made it 1818. And eventually we got the government. The president gave it to the People's National Movement, Mr. Patrick Manning, the Prime Minister, and then we went on again in 2002. So all in all, I spent 16 years in the Parliament. It's the first time any representative from Tanapuna represented Tanapuna for more than one term. I contested the election 5 times and successfully won 4 out of the 5. In 2002, we met Mr. Carlos John, who was a hot favorite, and again he beat the dust. We won the seat again. And the time I spent in Parliament, it was very exciting. I was fortunate to have to sit on both sides, in government and in opposition.
His friend Kenrick Thomas is proud that the man who never knew his father and discovered his mother late in life rose to such prominence in society.
Well, he got to know his mother late, very late. And his mother told me quite a lot of things. His mother is an Indian woman who grew up in Thackray Orphanage. And her name is, she's dead now, her name is Thelma Hart. But her, as it used to be in the orphanage in those days, they used to christen people, give them a Christian name. Her original name, you'll be surprised to know, was Kalpatia. That is the only name she had. That is the name he knew also. But she was christened and called Thelma Hart. And incidentally, he resembled her too bad. Well, I don't know who his father is. He says some policeman, I don't know.
Apart from serving in Parliament, Mr. Hart functioned in government as Parliamentary Secretary in the Ministry of Sport, Minister in the Ministry of Education, and Minister in the Ministry of Culture, Community Development, and Gender Affairs. Mr. Cecil Walker, former Director of Physical Education and Sport in the Ministry of Sport, shares some observations of Eddie.
While he was in our ministry, Eddie showed the kind of dedication and will to help children that I really, really admired. He was one of the coaches who worked frantically. He has given so much that he doesn't have sufficient time to concentrate on the masses. You know, he would want to give A, B, C, D, E, and go all over his constituency and try to offer his assistance. And then you can give so much and no more. So he is not a true politician as we know it in Trinidad and Tobago. He's more of the statesman-like type of person where you do things for the development of your country.
Mr. Neville Chance, who worked with Mr. Hart, experienced his managerial and organizational skills and concerns for the people.
People-focused, service-oriented. Indeed, many of his constituents, and indeed the people in Trinidad and Tobago, considered Eddie as a voice of the small man in Parliament. His leadership skills, I think, stand out. Those skills he acquired in several years, more than 42 years in the Eddie Hart League, serving the people. He was able to organize an advisory team to support him. He also established a community organization called the Heart Connection, which was also an important instrument in implementing the many programs and projects that he had.
Mr. Hart served as Member of Parliament for 15 years. Some of his outstanding contributions in Parliament include the bills pertaining to illegal quarrying, Carnival 2007, and the budget debate of 2008.
Mr. Speaker, I rise proudly to take part in this budget debate because I'm extremely happy to see the positive transformation that is taking place in the quality of life of the people of Tanapuna and indeed the people of Trinidad and Tobago in general. But, Mr. Speaker, the part that touches me most is the transformation that is taking place with the grassroots, the small man and the woman, the single parent, the vulnerable, the specially challenged, and indeed, Mr. Speaker, the young people. Mr. Speaker, I know what effect the programs and projects of this government have had on the grassroots, because they tell me so every day. And more importantly, Mr. Speaker, I am a grassroots all my life and will remain one.
Speaking on bills that concern the man in the street, like the dangerous dog act, where the AG at that time, Ramesh Lawrence Mara, had brought it to the house, where there was a big outcry where he had pit bulls murdered someone and that sort of thing, and we debated that at that point in time. I remember in government the police reform bills. At the conclusion of that, after I spoke, the Prime Minister, Mr. Manning, got up and he came, he shook my hand, excuse me, and he told the cabinet that that is the best contribution that he heard in the House, and I felt very, very good about that. I also made a good contribution as regards the illegal quarrying, which I see is still going on in this country.
I wish to add my support to the State Lands Amendment Bill 2006. This bill could not have been brought before this Honorable House at a more appropriate time. Mr. Speaker, my understanding of this bill is that it seeks to increase the penalties for illegal quarrying above those which are currently prescribed in the State Land Act, Chapter 5701. Mr. Speaker, the people of Tanapuna Piako Regional Municipality in general, and of the constituency of Tanapuna in particular, have suffered for a very long time from the impacts of the destructive practice of illegal quarrying. Mr. Speaker, I want to make it crystal clear. Carnival 2007 was one of the best carnivals ever. Mr. Speaker, because of what was happening in the Savannah, the Queen's Park Savannah, the mass was on the road. And Kitchener, Calypso, you know, the road make to walk on Carnival Day. And all the revelers, all the mass bands, all the band leaders would tell you they had a jolly good time on the streets of Port-of-Spain.
But all in all, I have some happy moments of being in the Parliament and the constituency where I spend most of my time, you know, because you have to do a balancing act. You have to share your ministry work with your constituency work. And in the constituencies, I paid a lot of emphasis to improve the quality of life for the people in Tanapuna. The roads, the bridges, the drains, the community centers, the recreation grounds. We did a lot of work there. I still follow up the politics. I'm still in the party group. I'm still in the village council. And I'm still doing my community work with the football, the cricket, the sports, and this sort of thing. We have some social programs in place. I'm sorry at that point in time that I can't continue at all, but there are some that I definitely want to keep going, like the Art League for football after 42 years, the Little Children's Christmas Party, the annual boat ride we have. There's never a dull moment with me in the community, always doing something, you know.
Now that his active political days are over, Eddie Hart continues to focus on his love of sport, the development of youths, and music. Edward Hart, while described as being down to earth, is indeed a true statesman and parliamentary personality.
This is the Parliament Channel and Parliament Radio 105.5 FM. This is the Parliament Channel and Parliament Radio 105.5 FM.
The Honorable the President.
I think they haven't been upstairs. Chair. I think I'll do it later. Yes.
Welcome back, everyone. So we will now resume the committee proceedings.
Clause 19.
The question is that Clause 19 stand a part of the bill. The question is that Clause 19 now stand a part of the bill. Those in favor say aye.
Aye.
Any against? The ayes have it. Clause 19 now stand part of the bill.
Clause 20.
The question is that Clause 20 stand part of the bill. The question is that Clause 20 now stand part of the bill. Those in favor say aye.
Aye.
Any against? The ayes have it. Clause 20 now stands part of the bill.
Clause 21.
The question is that Clause 21 stand a part of the bill. The question is that Clause 21 now stand a part of the bill. Those in favor say aye.
Aye.
Any against? The ayes have it. Clause 21 now stands part of the bill.
Clause 22.
The question is that Clause 22 stand a part of the bill. The question is that Clause 22 now stand part of the bill. Those in favor say aye.
Aye.
Any against? The ayes have it. Clause 22 now stand part of the bill.
Clause 23.
The question is that Clause 23 stand a part of the bill. The question is that clause 23 now stand part of the bill. Those in favor say aye.
Aye.
Any against? The ayes have it. Clause 23 now stand part of the bill.
Clause 24.
The question is that clause 24 stand part of the bill. Senator Ramdeen, you have circulated proposed amendments to clause 24.
I withdraw my amendment to 20. And yeah.
So
I was wondering if that was necessary in relation
Senator
to
Ramdeen.
in relation to E5.
No, Senator Ramdeen, please.
I'm sorry, Madam Chair.
You're withdrawing your amendment?
No, I'm asking the AG if he considers that is necessary in 3E. Yeah.
Yeah, it really ought to be deleted. And at the bottom of page 17. Yeah. So and does need to be deleted? Oh, no, sorry. Before accepting or rejecting a plea agreement, the court shall make inquiries of the accused person, whether the accused person, so it's meant to be conjunctive so that all of the conditions A, B, C, D, E, and F apply.
AG, having regard to the Madam Chair, through you, to the Attorney General, having regard to what we put in the earlier clauses with respect to the right to not to self-incriminate.
Yes.
I was wondering if we shouldn't add that.
Yes, we could.
To the list of rights that you have at E.
I had lifted presumption of innocence from this clause into the other one. Just give me a moment on that. Yeah. Testify in his or her own defense or remain silent. Do you think that we should express the right differently? Because the right to remain silent is technically a right not to incriminate yourself.
Well, it's a little bit different. You can have the right to silence. And
I have no objection to putting it expressly as per the Constitution.
Yeah. I think it's different because you have the right to remain silent.
Yeah.
You have the right to say something. You can say something and not incriminate yourself.
Let's add it in.
Yeah.
We can perhaps put it in between 1 and 2 and renumber consequentially, Madam Chair.
Sure. So is aware of his rights, including the right to plead not guilty, 1, and then you want to put in a new 2?
Well, actually, we could put the right against self-incrimination as number 1 itself.
Yeah.
So perhaps we put a new 1, including the right to not incriminate himself, or the right against self-incrimination.
Yeah, that's
the right. Well, it's a right to not incriminate himself.
Yeah. Okay. Okay, so including the right to 1, not incriminate himself, correct?
Yes. And renumber will happen consequentially and is needed at the end of Roman 6.
Yeah. So, Honorable Senators.
Before I go, Madam Chair.
Yes.
Just want to, if you go to Senator Ramdeen's amendment, you'll see where he's asking that we insert a new a G. Let me just go back. Yeah. Under 24.3, we have E, and then we have Roman right down. Then we go to F. He's proposing a G, and to read was improperly induced, was not improperly induced to enter into the plea agreement. So I was just proposing that we deal with that one time.
So that'll be a G. So you're proposing a G at 24, a 24.3G,
yes.
Correct?
Yes.
And the 24.3G will read, was not improperly induced to enter into the plea agreement?
Yes.
Attorney General?
I'm okay with the concept. I'm just looking at the wording to make sure that we've got it right.
Okay.
Because the court really should make an inquiry as to whether there was an improper inducement or even coercion.
Right.
But insofar as we've termed coercion inside of yes. So I think it should go in, and let's just see how we can express the language. So before accepting or rejecting a plea agreement, the court shall make inquiries of the accused person in order to determine whether the accused person, we really want to say, was improperly induced into entering the plea agreement. So perhaps we can use that language as a new G. And then that would take care of the difficulty that we had in the and. So we could delete the and from Roman 6 and then leave F as it is.
So you're taking off the and? You're proposing
Take off the and.
Yeah.
In F, remove the full stop and insert a semicolon. Put the word and after that. And then G, a new G.
Well, remember, it will be re-lettered appropriately because you had put in a new one.
No, that was Roman 1 in E. So this is now a G.
Sorry, yes.
So
yes, G
from the
and
chapeau, the chapeau would read, before accepting or rejecting a plea agreement, the court shall make inquiries of the accused person in order to determine whether the accused person was not offered an improper inducement. Yeah. To link it to...
It was improperly induced.
Was not.
Was not improperly induced.
Well, no, the inquiry that the court is making is
Yes.
whether they were improperly. You could have it improperly induced or not improperly induced. It doesn't make a difference. The inquiry is either in the positive or in the negative.
So the drafters have provided the language to catch the thought being, so the court shall make an inquiry, that I'm translating the chapeau, the court shall make an inquiry as to determine whether the accused person was offered an improper inducement.
So it'll be and G.
Yeah. So we could go, was offered an improper inducement. I think that would catch it. Was offered an improper inducement. And I think that this, I thank Senator Mark and Senator Ramdeen because I think that this further strengthens the odium that we were trying to protect against.
Was offered, not was not.
Was offered. So the court is making an inquiry as to whether the accused was offered an improper inducement.
Okay.
Yeah, and what we could do is to further qualify it to the two stages of was offered an improper inducement to enter into plea discussions or conclude a plea agreement. So at both stages.
So we put, yeah.
So was offered an improper inducement to enter into plea discussions or conclude a plea agreement. Madam Chair.
Senator Ramdeen, you have a further amendment to clause 24 at 24.5.
My proposed amendment, AG, was to, I know that the victim impact statement is going to be prepared by the prosecutor. Clause, your subclause 5 allows the accused person with leave of the court to cross-examine the victim on the victim impact statement. And I was wondering if circumstances arise where the prosecutor may also want to challenge anything that is in the victim impact statement, if we should make provision for that.
I have no objection. I actually was torn myself, not only on that point of either party, but whether any re-examination would have been necessary. Some of the literature that we looked at and the direction sort of said, well, look, it will be unfair to put the person through the ordeal. But I wasn't wedded one way or the other. I was looking to the propriety of the case. I welcome views across the benches. Perhaps Senator Choate, through you, Madam Chair, may have a view on this. That's the accused, either party having, with the leave of the court, the right to cross-examine, because I think that the qualification with the leave of the court is safe enough. So,
I agree, unless you want to say something to the effect of, to the extent, well, in the interest of justice, or where the court deems fit, or something like that, but it's the same effect.
I'm wondering if I can use, as opposed to accused person, would either party really capture? So far we've been using prosecutor and accused.
Do you want to spell it out? There's only two parties.
Yeah.
It can't be anybody else.
So, an accused person or prosecutor. Prosecutor and accused person with the leave of court. Yeah, the prosecutor may have certain.
Madam Chairman, I don't follow that at all, because as I understand it, the victim really is the prosecutor's witness.
We were just
So
literally discussing that.
cross-examine your
Your
own
own
witness.
statement and your own witness, unless the person was deemed to be a hostile witness, and you would have to, yeah. So insofar as the accused person, insofar as the prosecutor has prepared the witness statement, the victim impact statement, sorry, I think that we may, unless there was a re-examination that was really necessary.
Is it that he's really being called as a witness for the prosecution? Why don't we take all the word cross-examine and then just question them?
Well, this came from the opposition bench downstairs. I think it's fruitful, it's useful to put in the leave of the court to cross-examine the victim. And insofar as we really have the prosecutor preparing, redacting, etc., the statement, I think that we would be safe to leave it as it is. I mean,
but if the prosecutor wants, if through some reason, after the cross-examination, like in our civil jurisdiction with re-examination, something arises as a result of the cross-examination that the prosecutor wishes to clear up or get some further information on, how is that going to be accomplished?
I don't know if that's cross per se.
No, I'm not saying, I'm saying outside of the words cross-examination. If a situation arises where the victim says something that the prosecutor may want to clear up for some reason, then this doesn't make any provision for that.
It's true, but I'm wondering if insofar as that falls to be persuasive evidence at best, or a reflection that it couldn't be done by way of submissions.
Well, may I respectfully suggest, first of all, I'm a little uncomfortable with cross-examination at this stage. I was wondering, it's just a thought, that perhaps we should say an accused person may, with leave of the court, ask questions of the victim on the contents or about the contents of his victim impact statement. If we put it in context of cross-examination and re-examination as it operates in the trial courts, what we will have is an extremely hostile environment where victims may have to endure the very same trauma that we're hoping that they have to avoid by use of this piece of legislation, first of all. And secondly, if that happens, what you're going to see is the prosecutors are going to stand up and re-examine for an hour to show how traumatized the poor victim had been by the whole affair. And the process becomes skewed and ripe for appeal. So I'm respectfully suggesting that the accused person should be given the opportunity to ask questions, certainly. But whether we should use the word cross-examine, I'm not so sure. One, because it makes it too adversarial, and secondly, because re-examination spins out from that. And you don't want that.
The judiciary's perspective on this was very much that offered by Senator Choate. In fact, the original version of the bill excluded cross-examination clean. Arising out of the debate in the House, the opposition had asked us to consider the cross-examination. A number of Commonwealth jurisdictions have the cross-examination so described. Ireland, in particular, jumped out at us. A number of the jurisdictions. Jamaica as well has it. I do find it very interesting, however, the sort of hybrid newness of may ask questions, because it isn't cross-examination per se, and it may therefore give an indication as to what Parliament intended in terms of the severity of putting the witness through it. But I think in counterbalancing it against the rights of the accused to deal with something which may be deemed to be adversarial or impact upon the court's consideration of the plea agreement, that there is definitely a balance to be had. This proposal for amendment, in fact, came from the opposition. I'm wondering, through you, Madam Chair, what the view in light of Senator Choate's submission is.
Madam Chair, I'm just wondering whether the removal of the word cross-examine and the insertion of the word question the victim, I know it will imply something substantive, but whether simply changing cross-examination with question, so that with leave of the court question the victim, and that seems to convey the intent of ensuring that the accused has his right protected, but at the same time the adversarial nature of the situation is minimized. So I'm just recommending question versus cross-examination.
My only fear from a legislative perspective is that in a court context, introduction of language which is short of examination, cross-examination or re-examination is a departure from the norm. So a court is going to have to consider what Parliament in its wisdom intended in questioning or asking questions, and then they would look to what we've had to say or be called upon to decide. So insofar as we had prescribed an effect to the extent that the court allows, we had limited by that language the manner in which cross-examination could potentially be handled. So I'm wondering about, I find it novel and very interesting, Senator Choate and Senator Mahavir's submissions. I'm wondering if in terms of precision we should keep the cross-examination as it is carefully dealt with to the extent that the court allows. I think from the perspective of a re-examination, that we should certainly move away from it for the reasons that Senator Choate has put forward. So I'm wondering if we should leave the clause as is.
Senator Ramney. Senator Ramney.
Yeah, Madam Chair, I think the difficulty with introducing any other term except what we're accustomed with in adversarial proceedings is that it leaves the door too wide open and there will be no limitation. The fact that you have with leave of the court, like in jail proceeding, you will have to say what paragraph and what it is you want, so that it will be court controlled in any event. So I think we can leave it as is.
So will you withdraw your amendment?
I will.
Yeah. All right, so honorable senators, the question is that clause 24 be amended as follows. In 24 sub 3 E, to include under E is aware of his rights, including the right to 1, to not incriminate himself. Go down, everything will be renumbered accordingly, but at 6 to remove the word and then to introduce at F the word and at the end, and then introduce G, was offered an improper inducement to enter into plea discussions or conclude a plea agreement. Those in favor say aye.
Aye.
Any against? Any against say no? The ayes have it. Clause 24 as amended. The question is that clause 24 as amended now stand part of the bill. Those in favor say aye.
Aye.
Those against say no. The ayes have it. Clause 24 as amended now stands part of the bill.
Clause 25.
The question is that clause 25 stand part of the bill.
Yeah, Madam Chair.
Yes, Senator Mark.
I didn't circulate an amendment. I did not circulate an amendment, but just would like, through you, to raise this matter again with the Attorney General. And I'm looking at 25 sub 2. Here it is, Attorney General, a court is finding and determining that there was improper inducement offered to a suspect and or an accused person, and the court is rejecting the plea agreement. But nowhere in this clause am I being told that the court, through the judge, can impose a jail term and heavy fines on the perpetrators of this crime. And, you know, you ask yourself the question, is this thing going to work? Because it seems to me that where people are guilty of breaking the law, it does not appear that there will be any sanctions or penalties. And, Madam Chair, I can't understand, as a lawmaker, taking part in an exercise in which I am seeing before me the court is determining a matter, and yet still there is no provision in the law that gives the court the power to impose what I call penal sanctions. And this is what I would like the Attorney General to clear up for me. Please.
Attorney General.
18-minute breaks revive the soul, Madam Speaker. Madam Chair, I do hear Senator Mark loud and clear. I think the answer to the position is that it is from this point where a court makes a determination that there's an improper inducement, that the common law relief that we're looking to rely upon really has a springboard. So whilst there's no express provision as there was in Section 5 of the 1999 Act for criminalization, it is from this point here, in fact, that we now have a court making a determination of an improper inducement, having done the inquiry, as we've usefully added in clause 24 above, and that the second stage of affairs can move from those who are willing to take it forward. So the point is noted, but respectfully, I don't think that we can add it in, bearing in mind the policy point that we've adopted so far.
Madam Chair, if I may again be allowed, we're talking about the prosecution involved here, that is the DPP. And the DPP or his representative is prosecuting a case before the court. And the court finds that the DPP or his agents engage in improper inducement. How can we sit here knowing that it is the prosecution, in this case the DPP office, that is engaged in this thing, and we are expecting the judge to tell the DPP to take action against itself? We have to impose action on the DPP as a parliament.
Senator Mark, I think
so. I'm just making that point.
I think your point has been made. Senator Ramlin, is it the same point?
No, it's not.
Yes.
AG, can I suggest, having regard to your policy position, on an administration of justice point, can we not have a subsection that says where a court makes a determination in accordance with subsection 2 that the court refers the matter to the Commissioner of Police for the appropriate action to be taken, so that we don't get into the realm of interfering with your policy position. But at least I hear Senator Mark, I hear you on the policy position, but I think it is useful. The fact that it is referred to the Commissioner of Police, you can't refer to the DPP because there is a problem there. But the investigative arm of the state is really the Commissioner of Police. And I see nothing wrong if the Commissioner of Police gets the matter. It happens all the time in high court matters, in civil matters. Something is wrong, there's some fraud or something, is referred to the registrar, to the Commissioner of Police for appropriate action to be taken. It has a safeguard, there is an independent institution that is investigating it, and it also has a safeguard that if nothing has gone wrong, then nothing will come out of it. But it, at least from our point of view, without trespassing upon your policy position, the fact that the court refers the matter to be investigated, I don't think that will trespass upon the policy position taken by you.
Thank you. Very useful submission, taking into account existing practice which happens. The odium at this stage, which we seek to keep under control, is the mere fact that a court has been invited to physically take a step, which is a part of the court record, which will now become public, that it has referred a matter to the Commissioner of Police, which in and of itself could cause the difficulties that we're seeking to move away from in the repeal of Section 5. In keeping with the philosophy of using the implied sanction, the common law, whatever it may be, that use of the registrar's referral via the judge's referral to the registrar is still an aid to operation here. But at least the judge would have had a finding. I think it is from that point that we prefer to take it in stages, therefore. And whilst it's a very useful submission, I'd prefer, in keeping with the policy position that we have, that respectfully that I disagree with adopting it for now, but it's a very useful submission.
So, Honourable Senators.
Okay, could I just, the point is a valid one, AG. Thank you, Madam Chair. What harm would it do to your policy, Honourable AG, if you were to add, after agreement, and undertake other appropriate action as it sees fit? So you broaden the remit of the court, in addition to rejecting the plea agreement, and undertake other appropriate action, which is wide and broad and gives the court latitude to do what Senator Ramdeen says ought to be done.
Because the court has that in any event. I don't need to express it. It has the jurisdiction to act that way.
Madam, if the Attorney General is saying that the court has the jurisdiction, the court may very well look at these proceedings and the court would say expressly that we've decided not to impose any sort of sanction. And the court might be very well saying, because of the policy of the government is not to visit the prosecutor with criminal sanctions. And thereby, the court may say, well, because that is the policy behind the legislation, then although the Attorney General is saying the court has that power, the court may very well say, well, since it's not intended for the prosecutors to be penalized or in criminal law, then I am not going to refer the matter because that is not the policy behind the act. I'm not going to refer it to the police.
Attorney General.
I think the converse could be equally argued because there's no prescription against it, so that there's nothing to stop the court from in fact making the referral, which happens on a daily basis, in particular in criminal matters.
So, Honourable Senators, the question is that Clause 25 now stand part of the bill. Those in favour say aye. Aye. Any against? I think the ayes have it. Clause 25 now stand part of the bill.
Clause 26.
The question is that Clause 26 stand part of the bill. The question is that Clause 26 now stand part of the bill. Those in favour say aye. Aye. Any against? The ayes have it. Clause 26 now stands part of the bill.
Clause 27.
The question is that Clause 27 stand part of the bill. Senator Ramdeen, I believe you have circulated an amendment.
My amendment treats with 27(1)(b), where what I think we want to do is to prevent someone from jumping the queue and listing the matter back for trial in the High Court. I'm not familiar with what is the position under the criminal procedure rules, but if there is a listing, if there is a listing judge or a case management judge on the criminal procedure rules, I think it would be better to send it back there. Because you can have a situation where an accused person will embark upon this procedure to jump the queue, and then once you're at the head of the queue, you reject the plea agreement, and then your matter is fixed for trial in any event. So I'm just saying, perhaps the wording of it might not.
Yes.
Perhaps the wording of it might not be totally in sync with what may have been the mischief behind the particular section. But I would have thought that we wouldn't want people to abuse the legislation by going through that mode.
Thank you, Senator Ramdeen. The clause is articulated against clause 22(1)(b). So in clause 22, if a plea agreement is filed at any time before an accused person is committed to stand trial in the High Court, the magistrate shall cease the conduct of the committal proceedings if they've started and transfer the matter to the High Court for plea agreement hearing. If I understand the submission, and please correct me if I've got it wrong, the submission is that the jumping of the queue may happen and that you may in fact be still in the magistrate's court undergoing some form of committal proceeding. Now it would be premature of me to suggest that committal proceedings may be, how should I say, put out of the law very soon, because I can't be presumptuous about that. But the point is useful. So if I've got it right, instead of list the matter for trial in the High Court.
Well, you've raised an interesting point. If you stop the committal proceedings, you go up, and it comes to an end. In the case of the magistrate.
So we have A. So A still kicks in. The judge may send the case back to the magistrate's court
for
the conduct. And then B, or list the matter for trial, assuming that you're in fact at the High Court level.
That presumes that you would have finished your committal proceedings and would have embarked upon a plea agreement after you've been committed.
Yes.
So you can embark upon the committal, you can be committed, embark on the, I'm committed to stand trial in the magistrate, from the magistrate court to the High Court. I have to wait 5 years to get an indictment. I tell you I want to enter into a plea agreement. The DPP has to file the indictment. You reach up to the High Court. I then pull back on the plea agreement, and then you have to list me for trial. So I'm still able to beat the system.
I see.
So I think what would be appropriate is if the legal research team could find out under the criminal procedure rules if there is a listing judge or what is the mechanism under the criminal procedure, because there must be someone who does the criminal case management. That would be the most appropriate person to determine for it to go back before, and that person then decides how they treat it from there. The independent judicial officer who would know what the position is. If he forms the view that it was done having regard to whatever submissions may be made or looking at the facts of the case to beat the system, then he will take the appropriate action. We're not prescribing what is to be done.
What I'm cautious to do is to not bind. I accept the point. I think the point is well thought out. I'm cautious not to bind myself to an existing rule which can be subject of amendment by the Rules Committee. So I'm wondering if we should make a reference to treatment via the rules, not necessarily listing per se. I don't need to be specific about which rule applies. But perhaps we can just have a look at a formula of words to avoid the potential
I'm concerned about just listing it for trial. you're going back to a jurisdiction that only have one magistrate, like my arrow.
I'm being reminded through you, Madam Chair, that one of the provisions that we specify is that the DPP must file a draft indictment together with the plea agreement. So there would already be an ability for that. You wouldn't technically be waiting for an indictment to come in, which is as yet in limbo. That already in that plea agreement, your indictment is there.
A draft.
Yeah, it still needs to be formalized. But the gap between the formalization of the draft indictment and an indictment, I'm wondering how that plays into the submission that you've given in the example.
Well, I don't know how I don't know how that's going to play, because right now the position is that when you're committed, depending on what you're committed for, you're lasting a long time, for you 4, 5 years, 6, 7 years sometimes, before you even get the indictment.
Madam Chair, could I ask whether Senator Choate has any views on this? So the mischief we're looking at is the jumping of the queue, where you're listed for trial, listing the matter for trial in the High Court. And that's in, yeah, the case progression officers, yeah. Sorry, Senator Rambarat was just through you, Madam Chair, referring to the fact that under the criminal proceedings rules, there are case progression officers.
Right, so why we don't send it back there?
Well, you see, I'm wondering, insofar as rules are subsidiary, do I really want to use the terminology of the criminal proceedings rules? Because they change from time to time. If I send it back to the High Court to list for trial, it still has to go and hit a case progression officer in accordance with the rules.
Well, not if you say to send it back for trial.
But what we're doing is we're list the matter for trial. Because to list it, you've got to go through the case progression officer. So it's the equivalent of the registrar getting involved in that process.
Well, Madam Chairman, if I may, first of all, a judge can't list a matter for trial. And with the introduction of the rules, the way in which matters will be listed will not come within the jurisdiction of the judge. So I'm respectfully suggesting instead
refer
that,
the matter.
The judge may adjourn the matter for a date to be fixed for trial. Because the judge can't fix a date for trial for another judge.
How about refer the matter for listing by the High Court?
I'm thinking that perhaps you need something stronger than that, because simply because the bureaucracy would operate in such a way that unless clerical officers don't get a directive to do something, it's not likely that they will do so. So, adjourn the matter for a date to be set for trial is within the lingo, the existing lingo. So, I'm suggesting that something along those lines be used.
I think that could work, those exact words. Because it would fit within the construct of how the court system operates, and it would imply a process to happen. So, as opposed
process, if I may suggest, is that it be referred to the registrar. The registrar is the one who will determine whether it goes on a cause list or for case management. So at that stage, if you use the words refer to the registrar, and whatever words you deem appropriate thereafter, that should cure it. So you are not bound by the language of the criminal procedure rules with respect to the case progression manager and so on. The registrar is the person who determines what is put on a cause list or a trial list and so on.
Sure. So shall we look at it through you, Madam Chair, together then? So as opposed to list the matter for trial, we'll either refer the matter to the registrar for listing, for listing of the trial, for listing.
he may determine that it shouldn't be put on a trial list, but put on a cause list, and thereafter the judge on the cause list will determine whether it should be put on a trial list or whether it should be sent for case management.
I am a little, Madam Chairman, I'm a little afraid of that. I'm a little afraid that sending it off to the registrar and just saying this is a reference we put back on a list could result in somebody's file sitting in a drawer for years, for 2 years.
Or 12.
as occurred with quite a number of people a few years ago. So I would suggest that we use the word adjourn so that it is still considered to be within the jurisdiction of a judicial officer to deal with. The practical listing of the matter would fall under the authority of the registrar. So I don't know how to combine those two things, but I think that perhaps we need to have both of those things in whatever new version of 27(1)B we may have.
Senator Sturge?
If I may suggest, it might be easily cured, so it doesn't sit in a drawer for 2 years. If you say refer to the registrar for listing within 30 days, you give a time frame so that he or she has to list it within a stipulated time frame.
Then Senator Ramdeen's mischief crawls in, which is the jumping of the queue.
Well, jumping of the queue would relate to a trial. But if he's listing, he has to first list it to a cause list or a case management hearing, which is not a trial. And at that stage, the judge will determine, once it's listed on a cause list, it comes before a judge, or listed on a case management hearing, it becomes before a judge. And the judge determines whether it goes on a trial list and who should have priority in front of him and so on.
I'm attracted to the concept of adjourning before the judge that has the file, because you've got to come back up on an adjourned date with some result, and therefore you don't escape judicial attention. You get to knock on the door, the judge can give a reason. So for I find it very attractive to keep it before the judge and have the matter adjourned for listing. I think that the judiciary can then take care of the consequences as to how this mapping will actually work. So perhaps we can use, instead of list the matter for trial in the High Court, adjourn the matter for listing of the trial in the High Court.
Should it not still be within 30 days to take care of what Senator?
Well, you see, I think at that point, bearing in mind the difficulties in the listing per se, the time frames, the fact is that either party still has the right to knock on the door of the judge to say, well, what's going on? And certainly the judge can't just adjourn without a date. The judge would have to at least return to give some form of indication. So I think that could take the hybrid of the two things.
Well, as it happens, judges do sometimes adjourn for a date to be fixed by placing it back on the cause list. There's no determinative date when it's put on the cause list. So if you stipulate 30 days, you are not saying 30 days for trial. If you are saying it's adjourning, but and if you want before a judge, but at least you give a time frame, the judge at that stage, if not the registrar, since the registrar is problematic, the judge at that stage can determine, well, it's now before me, it now has to come before me within 30 days, I have to put it before me in 30 days, and on that day I'll determine if I put it on a cause list, a status hearing or a trial.
I think that fits in, through you, Madam Chair, with the philosophy that we've used in prescribing dates in this particular bit of, in this bill, you see 14 days and 7 days, etc. So can we get the language, through you, Madam Chair, that Senator Sturge is suggesting? Adjourn the matter
to come up before.
So adjourn the matter for listing
before the judge.
Adjourn the matter
for listing before a judge within 30 days, or whatever the quantity of time the Attorney General might think best.
So the proposed amendment is...
Well, we can actually, sorry, Madam Chair, perhaps adjourn the matter for listing within 30 days?
Yeah.
And then that could just simply take care of it?
Yeah.
So take off the words before a judge?
Yes, ma'am. So I wonder if we need adjourn the matter So if an accused person withdraws from a plea agreement, fails to enter plea agreement at the plea agreement hearing in the High Court, the judge may, skip A, B, adjourn the matter for listing in the High Court. In the High Court within 30 days.
Senator Ramdeen, are you therefore going to withdraw your proposed amendment to clause 27 so that I can put the new amendment? So, Honourable Senators, the question is...
If a case is sent back to the magistrate court under subsection 1, committal proceedings shall commence before a new magistrate, as if the plea agreement had not been entered into. Where you have a jurisdiction like Mayaro or Rio Claro, where you have one magistrate, and the matter is sent back there, what is going to happen with that case?
The Chief Justice will have to find a new magistrate to treat with it.
Well, that might be so, but I think that to protect at least the process, at least we should put like a 30 days for that to happen, because if we don't do that, then that you can see a situation arising where
I fear that it may enlarge the very problem that we're seeking to move away from.
Which, no, how?
So if you put 30 days and a magistrate is not available because the magistrate is on that circuit for that particular point in time.
No, well, it's just, I don't see that there's any, the only sanction that can arise out of that is that the matter cannot be listed within 30 days before a new magistrate. And the accused person could then bring GR proceedings and force whoever it is, the registrar, Chief Justice, whoever, to list the matter. But the fact that there are jurisdictions in our country where you have only a sitting magistrate, it is administratively problematic, as we have it now, for the Chief Justice to take a magistrate from somewhere and bring them to a jurisdiction. Take, for example, Mayaro. You have one sitting magistrate. You have one court. So when is this matter going to be listed or heard if it has to jurisdictionally go back to that court?
Unless you agree to transfer the jurisdiction, which is possible.
Yeah, but I mean...
Madam Chairman, could I just suggest then, if it is so, if we're looking at the question of jurisdiction, maybe what we should say, if a case is sent back to magistrate's court under subsection 1, committal proceedings shall commence before a new magistrate in any jurisdiction. We can say that, as if the plea agreement had not been entered into. But if we don't want to say that, the fact of the matter is, it often happens after an appeal is heard and a matter has to be retried before a different magistrate, that arrangements are made for magistrates to go to jurisdictions where there is only one sitting judicial officer, perhaps for 2 afternoons or so consecutively, to deal with these matters. So it's not a fact situation which is unknown to the law or unknown to criminal practice and procedure. Of course, if you say in any jurisdiction, it makes it a whole lot easier.
I would believe that because it's something which is sorted out on a normal basis, either transfer of jurisdiction or a judicial officer is put in to, of necessity, deal with the matter, I think that we could leave it as it is. So Madam Chair, if I could in summary then say that clause 27 would be amended subject to the Senate's views in 27(1)(b).
Sure, well then let me put it.
Yes, please, Madam.
Attorney General. So, Honourable Senators, the question is that clause 27 be amended as follows. At 27(1)(b), to replace the words, list the matter for trial in the High Court, with the words adjourn the matter for listing in the High Court within 30 days.
Yes.
Yeah? Those in favor say aye.
Aye.
Those against say no. The ayes have it. Honorable Senators, the question is that clause 27 as amended now stand part of the bill. Those in favor say aye.
Aye.
Those against say no. The ayes have it. Clause 27 as amended now stand part of the bill.
Clause 28.
Honorable Senators, the question is that clause 28 stand part of the bill. Senator Ramdin, you have circulated an amendment.
No, AG, my amendment only goes to the time period. I thought that the 14 days was a little bit inadequate or too short for an accused person to. I think the new period under the Summary Courts Act 2 was 28 days. So I think we can go with 28 days.
I have no objections to the amendment.
So, Honorable Senators, the question is that clause 28 be amended as circulated. Those in favor say aye.
Aye.
Those against say no. The ayes have it. Clause 28 is amended. The amendment to clause 28 as proposed by Senator Ramdin has been accepted. So, Honorable Senators, the question is that clause 28 as amended now stand part of the bill. Those in favor say aye.
Aye.
Any against? The ayes have it. Clause 28 as amended now stand part of the bill.
Clause 29.
Honorable Senators, the question is that clause 29 stand part of the bill. Senator Ramdin, you propose an amendment.
AG, same, just equality. Yeah.
Madam Chair, similarly agreed that 14 in subclause 2 be deleted and substituted with 28.
Honorable Senators, the question is that clause 29 be amended as circulated. Those in favor say aye. Aye. Those against say no. The ayes have it. Honorable Senator, the question is that clause 29 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 29 as amended now stands part of the bill.
Clause 30.
Honorable Senators, the question is that clause 30 stand part of the bill. Senator Ramdin, you have an amendment circulated.
AJ, I looked at Madam Chair, I had looked at the form that you have in relation to section 30, and I was wondering whether it's prudent for us to allow the accused to appeal based on the grounds that you set out in A, B, and C, or on any other ground. I didn't quite understand the rationale of limiting the grounds of appeal to A, B, and C alone. I understand why you have A, B, and C, but without at this hour being able to formulate to you what may be other grounds upon which there may be an abuse of process with respect. These are obviously statutory because of what the Act provides, that there may be another ground or there may be other grounds upon which one may want to challenge the entering into the plea agreement. I just can't formulate it now. Sure. But I don't.
Just 1 second, Attorney General. The amendment that you circulated, we are on clause 30, correct?
Correct.
So you circulated an amendment for 30 sub 2 to delete 14 and substitute 28, and then to introduce insert after clause 30 sub 2 a new subclause 33. You're not dealing with those amendments.
No, I'm not. The AG is not going to, because of the policy position, I will not pursue the 30 subsection 2 amendment.
Which is to substitute 14 with 28?
No.
He means the introduction of the criminalization by the insertion of a new 33, which is the second item.
But you do understand that I'm trying to follow the format that you've presented, the
I understand.
amendments?
Why I didn't go to 32 as yet, Madam Chair, is because I'm dealing with 31.
But you haven't circulated an amendment
No,
for 31.
I know, I haven't circulated an amendment. I'm suggesting to the AG,
yes,
through you, Madam Chair.
No, I know. I'm just trying to...
So Madam Chair,
I just want everybody to know that I am...
We understand.
following the
list.
procedure here.
Yes.
So let me just clear it now. So you haven't started on what you've circulated as yet.
Well, I can deal with that. It's just as a matter
Please.
of chronology. I think you wouldn't have any objection to the 14 to 28.
No, sir.
And I'm abandoning
agreed
30 subsection 2 with respect to the criminal sanction.
So you're withdrawing that?
Yeah.
Okay.
And then there's a further submission on
And then
31.
last proposed.
What I'm proposing, AG, is that I don't see that is...
I got you. The question as to whether we should include a wider net for any other ground than that expressed in A, B, and C.
Yeah.
Madam Chair, sorry.
Sorry, please. Madam Chair.
Sorry to interrupt, AG. I was just going to say that if you circumscribe the
grounds,
the opportunities that someone who is pleaded guilty and wants to appeal against conviction or sentence, essentially what you're doing is you're saying to the person that you have a lesser right of appeal than somebody who is convicted and sentenced. And this may deter persons from entering into plea bargaining arrangements. I'm just suggesting. So I'm wondering, why not leave it simply to appeal against conviction or sentence, full stop? The law already says that when you've entered a guilty plea, to win an appeal is a difficult thing, because you will have to show, for example, you may have to deal with a situation of incompetence of counsel, person wasn't examined, that kind of thing, or the examination wasn't done by a properly qualified person, and so on and so forth. So if you just leave it open and remove the subsections, then it means that the person can appeal just like any other.
Thank you, through you, Madam Chair. So the mischief that we were trying to deal with in prescribing A, B, and C as we did was to get to the common root causes of what vitiates an agreement per se. So looking at it from a contractual basis, improper inducement, which we've defined, misrepresentation, prosecutor's breach, standard provisions. Both submissions, Senators Ramdeen and Choate, go to the same cause. There may be other circumstances which ought to vitiate an agreement of this kind, and therefore the question is whether we open it with a further element, which is some other circumstance which we cannot now contemplate, but which would be in the interest of justice to be considered, or to simply just allow for an appeal. It was in reflecting upon the policy positions coming from other jurisdictions as well that we looked at, that we really centered upon the contractual approach, the things which ought to vitiate an agreement. I'm open to the suggestion. I'd just like to reflect back onto our policy from our team.
Could I just say that one of the advantages that you might have of actually keeping the subclauses that you have as A, B, and C and adding on instead of cutting it out is that for the person who is not accustomed to drafting grounds of appeal like the normal prisoner, it might be easier for them to take from the legislation, if it's available to them, the grounds of appeal there. But that's just a thought that it might be more useful than to have to craft, someone who doesn't see this and have to craft why they should appeal. It may just assist that person.
Well, there was that in my mind, and also the fact that I wanted from a legislative perspective to say what we were focused upon, that we were focused upon this agreement. I'm comforted by the fact that improper inducement is so widely crafted as we've put it, because essentially that's anything involving all of the grounds that we've set out, which is now quite wide as we've broadened the definition of improper inducement in clause 2 of the bill. So I wondered whether we caught that there. So if you permit me, Madam Chair, just to double check the policy prescription that we had.
Madam Chairman, before AGP,
Sure.
I think before we go there, it just struck me. When you are convicted in the criminal courts, you have a right of appeal, right up to the Privy Council. So what we're doing here, talking about may allow the person to withdraw or to appeal and that kind of thing. We are affecting a right. So this needs to be reworded.
I just took a little look at section 13 of the existing law, which is the same formulation of words that we have here, which was an appeal on the grounds as stated here. I do note the submission that Senator Choate has just put on, which is your general right of appeal, which ought to be an unfettered right in the context just delivered as I've taken it. I need to just have a little look at this, Madam Chair.
Well, why? Senator Choate, why are you interfering with the right to appeal at all? Take out that. No, take out the conviction part and say that allow an accused person to withdraw from the plea agreement at any time before sentence based on the grounds. Because if you're convicted, like you say, you have the right to appeal anyway. And leave this just to deal with withdrawal.
Right. So this would mean.
Madam Chair, what crosses my mind here is that in 31, A, B, and C are proper reasons to withdraw, if you really look at it. I'm now cleaving in my mind a withdrawal versus an appeal. So if I were to look at this, 31, the court may, upon application of an accused person, allow an accused person to withdraw from the plea agreement if, skip the rest of the language, if improper inducement, misrep, breach terms. The question now is whether appeal can be cleaved to allow for a general appeal. But I think that the balancing act that was intended in the 1999 law, which this one repeats, was really the fact that you've taken the administration of justice through a whole process based upon an agreement, based upon participation, based upon circumstances. You've had due process, you've had your rights being explained to you, you've had cautionary aspects, you've had the court vet your discussion entry, vet the agreement itself. So we've occupied judicial time inside of here, and therefore it may be appropriate to deal with the agreements in this fashion. That's one of the arguments that can be offered, the balancing act. The question is this unfettered, is the point of the unfettered right of appeal. And that's where I'm now back to whether the two ought to be cleaved.
No, sure, Madam, sorry.
Sorry, AG, sorry, I was just mentioning to Senator Choate, why don't you just entirely, the right of appeal as drafted here after the comma after sentence is or appeal against conviction or sentence based on the plea agreement if, in any event, if you have a conviction and sentence, you will have the right of appeal in any event. So whether it comes as a result of the plea agreement or for any other reason, you are not taking away the general right of appeal, to borrow the words of Senator Choate. So this section only needs to deal with, because by virtue of the Supreme Court of Judicature Act, you will have a right of appeal there on conviction. So this is just, you just need, all that we will have to treat with is whether the fact that you have A, B, and C to deal with withdrawal from a plea agreement, because that is what we are dealing with here, it's whether you want to treat with having any other basis upon which you vitiate the plea agreement or allow for a withdrawal on any other ground.
I got you.
Yeah, and you just take out the part of the appeal.
Do you think, through the chair, that it would be prudent to expressly provide for that right, which was a right of appeal in any event, in a bold statement? Because we're moving from the 99 law, which expressly provided for withdrawal and appeal, on the agreements. Now just to the, you may withdraw.
Madam Chairman, if I may just add my 2 cents. The fact of the matter is, if you restrict the right of appeal, why would anyone want to engage in the process under this piece of legislation? Because you can still plea bargain according to the common law. You can still ask for maximum sentence indications under the rules. So it would make it unworkable. Apart from that, it would make it challengeable in the courts, because you would be affecting a due process right, I think. So I agree with Senator Ramdeen that perhaps what we ought to say is simply remove the reference to the right of appeal because it already exists, and then perhaps put in subsection D to deal with other fact situations which may arise.
I think that's very persuasive. I think that the elimination of the right of appeal can work. I'm just going to look now for the language that we should associate with a catch-all in a new subclause D.
Honorable AG may recommend under subsection D, there exist other reasonable grounds for vitiating the agreement.
Yeah, but
that should be our offense.
That's the only one in the act.
Madam Chair, I think that Senator Mahabir's recommendation may fit within the traditional language of grounds which we would put in any notice of appeal or otherwise, which is that there are any other grounds for vitiating the plea agreement. So, Madam Chair, what we would propose to do in 31 in the chapeau is to delete the words appearing after sentence, comma, in the 4th line, or delete these words, or to appeal against a conviction or sentence based on the plea agreement, and the comma as well. So you're deleting from the word comma, as they say. And we would insert, in subparagraph B, we delete the or appearing after the semicolon. In subparagraph C, we would remove the full stop and put a semicolon, and then insert the word or, and then we would insert a new subparagraph D, which could read as this: there are any other grounds for vitiating the plea agreement. Full stop. And then in subparagraph 2, delete the word 14 and insert 28. No? If an accused person appeals against conviction. So we would have, the accused person shall give notice of appeal in the form set out. Yes, I understand. Yeah.
To and take out the form.
Yep.
Take out form 9.
So we would have to delete subclause 2. We would be removing form 9, and we would be, of course, deleting the subclause 1 reference in 30. So 30 would read as 30,
correct,
with no subclause. Are you good with that, Amber? They did one disappears, two comes out because it's
Madam Chair.
Form 9.
Madam Chair, I do have a question, so before you put it before the House.
Okay.
Yeah.
So, if you have it, as the court may, upon application by an accused person, allow the accused person to withdraw from the plea agreement at any time before sentence.
Dash.
A, if it was entered. B, if it was so. Take off the O. C, put in an O.
Semicolon or.
Right, right, okay.
And there will be consequential
Yeah.
written to and
Yeah.
Form 9 in the
Yeah.
schedule.
Madam Chair, the drafters have suggested a slight modification to the
new D?
To the new D, and that it could read instead, there are any other grounds upon which the plea agreement should be vitiated.
Just a sec. Upon which
The plea agreement should be vitiated.
Okay.
So there are any other grounds upon which the plea agreement should be vitiated.
Attorney
Well,
General.
we could use set aside as well. Senator Ramdeen, through you, Madam Chair, would you prefer the word set aside as opposed to vitiated? So it would be set aside. So, Madam Chair, instead of vitiated, we use set aside.
Attorney General, Senator Ramki soon has a question.
Oh, I'm sorry. Yes, ma'am.
Thank you, Madam Chair. My question in relation to Clause 30, which deals with accused persons, is there a provision for a suspect to withdraw from a plea agreement?
Suspects are converted to accused because they have to actually get charged. So, through the plea negotiation process, to get to plea agreement, you have to admit you have to be charged, but you will have agreed upon the things that you should be charged. I think there's a consequential amendment to 28 where we make a reference to form.
All right, we'll deal with that. Let's deal with let's just deal with 30, and then if anything we will deal with the consequential amendment after. Attorney General, you ready?
So that should stay. That's fine. One moment, please, huh? Yes, so that's fine. Okay, that can stay. Yeah. Okay. Yes, ma'am, please.
All right, Senator Ramdeen, you are withdrawing all your proposed amendments to clause 30, right? Yeah. All right, honorable senators, the question is that clause 30 be amended as follows, and I'm going to read it out. Clause 30, there'll be no sub 1 anymore. And it will read, the court may, upon application by an accused person, allow the accused person to withdraw from the plea agreement at any time before sentence. So we are deleting the words, or to appeal against a conviction or sentence based on the plea agreement if.
No, we're keeping it.
Oh, we're keeping it, sorry, yes.
Just deleting from comma to agreement.
Yeah. Okay? And then we're adding, we are taking off after, at B, we're taking off the or that comes at the end, we're deleting that. At C, we are including a semicolon after the word agreement, inserting the word or, and then there's a new sub D, which reads, there are any other grounds upon which the plea agreement should be set aside.
Yes.
And subsection 2 is deleted.
Yes.
Honorable Senators, those in favor say aye.
Aye.
Those against say no. The ayes have it. Honorable Senator, the question is that clause 30 as amended now stand part of the bill. Those in favor say aye.
Aye.
Those against say no. The ayes have it. Clause 30 as amended now stands part of the bill.
Just be, of course, amending the marginal reference.
Yes.
By deleting "and appeal by accused person." So you would just read grounds for withdrawal from plea agreement.
Yes.
Clause 31.
The question is that clause 31 stand part of the bill. Senator Ramdeen, you've proposed an amendment.
Yeah.
Yeah.
I don't think you have any more
14 to
questions.
28.
Yeah. Through you, Madam Chair, sorry. Apart from the amendment to the time period, when you look at the substance of 31, it is the marginal note says application of prosecutor to set aside the plea agreement, conviction or sentence.
Senator Ramdeen, could you talk up a little bit?
Oh, sorry.
It's very difficult to hear you.
I'm sorry. AG, with respect to clause 31(1),
yeah.
The clause reads, notwithstanding an accused person's conviction and sentence pursuant to a plea agreement, the Director of Public Prosecution may seek the leave of the Court of Appeal to have the agreement, conviction or sentence set aside if the prosecutor was. If it is that the object of the exercise is to well, on the clause previously, we have dealt with setting aside by the accused,
yes.
And that application would be made to the court. If we are separating appeals and applications to set aside with respect to the accused, should we not follow the same procedure with respect to the Director of Public Prosecution? One, as a matter of drafting, but two, as a matter of correctness, having regard to the way we've treated the right of the accused to set aside. Unless there is some procedural requirement, I don't see why the Director of Public Prosecution would need the leave of the Court of Appeal. The Director, if he comes into knowledge of A or B, the circumstances that are prescribed by A or B, will go back to the court to set aside, which is what we did in relation to 30.
I'm just wondering whether we should have used the word set aside in 30, as you've mentioned it, because really it should be withdrawn.
What did we use?
We used set aside, but if I looked at the chapeau of 30, now that you've raised it in the context of 31, so the court may allow an application, and I'm going to address why we went to the Court of Appeal as opposed to the judge. So in 30, the court may, on the application of the accused person, this is at the High Court, allow the accused person to withdraw from the plea agreement. We've kept the appeal going to the Court of Appeal in the normal context by the deletion of the words there. So when we did the catch-all in D, and we put there are any other grounds upon which the plea agreement should be set aside, perhaps it should be any other grounds upon which the plea agreement should be withdrawn. And then that would make sense of 31, where the DPP is now asking for conviction and sentence of the plea agreement to be set aside, because now we're both of them in an appellate place. My question is whether we should broaden 31 now insofar as we've deleted the right of appeal, or rather the course of appeal in 30. So, Madam Chair, I'm wondering if I could invite you to reopen clause 30.
Well, let's deal with 31 first and settle what we are doing with 31.
Right, well, I'm
sure
that I'd like you, after that, to open 30, to change the word set aside to withdrawn.
But before you actually go there, is it not that if we set aside the appeal, there wouldn't be any requirement to withdraw because there would be nothing to withdraw from if you set aside the appeal. Sorry, not appeal. If you
the agreement.
If you set aside the agreement, and the purpose for which you're making the application is to get rid of the agreement, there wouldn't be a need to withdraw.
Well, the reason why I'm suggesting it is that we've put the concept of setting aside something in 31 in the appellate context. So for the DPP, we're saying, notwithstanding an accused person's conviction and sentence pursuant to plea agreement, the DPP may seek the leave of the court, notwithstanding an accused person's conviction and sentence pursuant to a plea agreement.
You see, I think the drafting is what is causing the confusion.
The DPP.
You have set aside that is being made in reference to agreement, conviction, and sentence.
Madam
Just
Chairman,
one sec.
sorry.
Yeah, just one sec. I think Senator Ramlin, I don't know if he's
No, if Senator Choate has a suggestion.
Senator Choate. Yeah.
Madam Chairman, I know it's a case of diminishing returns here, but if we look at clause 31, first of all, if you are convicted, having pleaded not guilty, the DPP doesn't have a right of appeal. The DPP, I believe, has a right of appeal in circumstances where a judge upholds a no-case submission. It is only in that kind of situation the DPP has a right of appeal. So if we give the DPP a right of appeal, where essentially what you want to do with this piece of legislation is encourage people to engage the plea bargaining system, I think that you might actually be doing the opposite. That's just a comment. Sorry. Yes. Yes, and the reason I raised this issue, as Senator Ramlin is reminding me, is because Senator Heath had made that point in the judge alone legislation, but it was not taken on board. It was made late in the day, but it was a very valuable point with respect to that piece of legislation. I don't want us to lose the opportunity or fall into the same error here.
But by the way, I didn't get to address it on the floor, but I did address it with Senator Heath. We didn't affect, there is no right of appeal in the judge alone. We left it as it was. So the law was fine, and he was okay with that point. I went back and I double-checked it. It was a good point raised. It doesn't dilute the point that you're making now. So is it your view that we should not permit the DPP the opportunity to disturb this conviction and sentence in circumstances where it may have been brought to his attention that there was turpitude in the course of the plea discussion, and in particular threats, force, bribery, etc.? Because I would think that those being very limited circumstances, that we should at least make sure that we balance the state's position in relation to this matter, where something has come into the zone, and we may want to bring it to the court's attention so that we, quote unquote, keep people honest in their approach towards plea bargaining and plea agreements.
Really, because of diminishing returns. But that really is a policy decision for you. But in any event, if we're talking about an appeal, we're not talking about an accused person. We're talking about a convict.
Yes.
If we're talking about an appeal, we should not be talking about having any agreement set aside. It goes without saying that if there is a conviction recorded on a false premise, then the conviction is set aside if the appeal is allowed. So we need to remove the word agreement. While I appreciate that the agreement is sort of like the philosophical core for the legislation, I don't think it needs expression in this clause. And in addition to that, I was thinking that perhaps just to be safe, that a subsection 3 C may be added to deal with any other relevant fact or any other relevant ground, something along the lines of 30D.
Yeah. Could I just ask through the chair why we would need to delete the agreement? And so you're proposing that in the chapeau, beginning with notwithstanding, that we should remove reference to the plea agreement?
Well, inferentially, that is what you are doing. You are saying that by setting aside the conviction and sentence, as you do in any criminal appeal which is allowed, what you are saying is that the basis on which that conviction and sentence was obtained no longer stands. So this is why I'm thinking it would be cleaner if you remove the word agreement. There's no need for the Court of Appeal to make a specific order to say this agreement is no longer valid.
I follow. I follow, and thank you. If I work my way backwards, perhaps a new C could read any other ground upon which the plea agreement, conviction, or sentence should be set aside. And maybe that may make sense of how we should treat with the chapeau in 31(1). We're just wrestling with how to express it now. Notwithstanding an accused person's conviction or sentence. Yeah.
Is going back to the fundamental principle that the DPP doesn't have a right of appeal.
Yes.
So that you have to have a mechanism. If you're going to the Court of Appeal, you have to have a mechanism that triggers jurisdiction.
Which is this?
Yeah, but this, no, but...
So this was intended to give the springboard into the appeal which doesn't exist. And it was intended to be specifically down to the fact of the agreement which we're doing now, which should be set aside for whatever reasons exist, intimidation, willfully misled, etc. So it was intended to be a very narrow appeal for something which was unappealable before, generally in terms of the DPP's approach towards convictions. So it's necessary to put in the right, if we want to have it in 31, that the DPP shall have this right to appeal, to set aside. So I can't see that we can't not have it.
Honorable Madam Chairman, I see what you're trying to do, but I think we're not following it through logically. It's either we're talking about the Director of Public Prosecutions now being given in this section the right to appeal against the person's conviction and sentence, the imposition of the conviction and sentence. If that is so, what you have here doesn't reflect that. What you have here is an application to have the agreement, conviction, or sentence set aside. Now, I don't know that we could have the leave of the court to have a conviction or sentence set aside without an appeal. I don't follow it logically.
Right, so the things which flow from the agreement being set aside, I accept, are sentence, etc. In the 1999 Act, in Section 15, there was the express right for the DPP to seek the leave of the Court of Appeal to have the agreement, etc., set aside. So we had lifted from Section 15 of the old Act and repeated it here. Pretty much in the same terms and conditions, giving notice, etc., and that the Court of Appeal will do whatever it does. The point is that the language as put really was intended to be quite expressive, that we were treating with all things which flowed from the agreement. I do accept the fact that obviously if you set aside the very thing from which you have started, everything else that flows after that doesn't exist because it's void ab initio. But I'm having a difficulty in how I should re-express it if I'm trying to catch the mischief that you're trying to solve.
Madam Chairman, if I may. If it is that you want to give a right of appeal to the director, you must say so in the language, that he has the right to appeal against the conviction or sentence.
But we've qualified it, because he has to seek, he's seeking leave of the Court of Appeal. They may say no.
No, but why would he need leave? Why are you allowing him?
Because of the fact that he didn't generally have the appellate right.
No, but leave will not, if the statute is going to give him a right of appeal, and he can only have that right of appeal by virtue of the statute, he wouldn't need the leave of the court.
Well, it's meant to be a two-step process. Go to the court, seek the leave of the court as to whether you can set it aside. If they give you the leave, then you can proceed to apply to set it aside.
No, but he can't get to the court unless he has the right of appeal. There has to be something to trigger the jurisdiction of the Court of Appeal to give him leave. So what is going to trigger the Court of Appeal to give him leave? You can't get leave without having an appeal to trigger the jurisdiction of the Court of Appeal.
Madam Chairman, that's absolutely right.
Got it. I've got you now.
Yes.
So the 1999 law itself had problems. If I draw the analogy to the Privy Council, even seeking leave to go to the Privy Council in conditional leave applications, you still have a right to go to the Privy Council nonetheless. You're just going through the phased approach of seeking the leave to get there, apart from then approaching it directly as you can. I see.
Another option, Madam Chairman, if I may suggest, this is really, I hate to say it, unfair to us, Honorable AG.
Madam Chair?
Another option is for us
Could I just interrupt for one moment? I too am watching the hour and honorable senators here, and I'm also very mindful that Senator Mahabir in our side discussions has warned me that he will be going on vacation at the recess, full stop, and don't call him till it's over. I mean that in the best way possible. I'm actually wondering if we could have, and I haven't spoken to the acting leader or to the chair, just continued with a few of the other observations, not staying much longer, but I would have proposed that we actually on the next day come back to complete this work. It will allow us to have some reflection on the clauses that we've stood down as well. So that's what I'm getting to. So I was minded that we wouldn't necessarily want to go too far into the night. I'm hoping that I haven't had a chance, Madam Chair, to discuss what date we will next come. Tuesday at perhaps 10 o'clock, and then we can seek to tackle the work in the committee stage and also start and complete the bail bill. So Madam Chair.
You could come to I don't know how will they come to this 10 o'clock thing. We have court. We have court. How are we going to do court?
I look like we need some help.
We have court on
Trinity.
No, but I mean, what's the time? It's 7, 8, 9 hours a year.
Madam Chair, I'm wondering, and I interrupted I took a lot of latitude in saying what I just did, Madam Chair. Thank you for that. I'm just wondering perhaps if we could just flag the issues in relation to the other matters to the end of the bill, as opposed to if there are areas where we can't form an immediate agreement, at least if I understand it, it would make the trip on Tuesday all the much faster, subject to your guidance, Madam Chair.
So as I understand it, Honorable Attorney General, members, you want to stand down clause 31?
Yes, please.
Yes? So clause 31 is stood down?
And what will follow, E.g., is 32 as well. You'll have to stand down 32 as well, because it depends on 31.
Yeah.
But may I put the question, clause 32?
We keep usurping your function. Sorry, Madam Chair. Please.
Clause 32.
The question is, clause 32 stand part of the bill? Attorney General, from what I'm hearing, clause 32 will be stood down as well, correct?
Yes, please. Because it's squarely related to 31.
Clause 33. Yeah? Go ahead.
Clause 33.
The question is that clause 33 stand part of the bill? The question is that clause 33 now stand part of the bill. Those in favor say aye.
Aye.
Madam Chairman, this connects back with a policy position which the Senate took earlier with respect to the evidence of plea agreements being used in the courtroom and whether they are allowed under the bad character laws. So I think, Honorable Attorney General, and I think very tiredly, that perhaps this needs to be looked at as well.
Yes, I think it was in relation to clause 12. It's either 8, 11 or 12 that we stood down.
Okay, so Honorable Senators, we will stand down clause 33.
Madam Chair, may I, with your leave and the leave of the Honorable Attorney General, propose that we stand down the remaining clauses for today, and we resume at 1:30 on
10:30.
10 o'clock.
Well, my colleagues we have a lot of colleagues who work part-time in this chamber, and we don't have the luxury of the full-time and all the money that you all get. So we have lawyers who have to be in the court.
Senator yes, Senator, no, I hear you. I just think that there's some discussions.
Yeah.
If it is that the issue of what time we're going to start, if that will necessitate extensive discussions, then I'm going to suspend and allow the discussions to take place and come back. Because at this stage, I don't think it is necessary to have the to-in and fro-in with the time.
Madam Chair, I don't think we have any difficulties with 10:30. My friend is a little tired, I appreciate. Yeah.
No, I'm dealing with my... All colleagues and so on have some challenges.
Having sat on that side of the house for 5 years and done my full share in the same capacity as others, the one thing that I recognize is that there's by far less pay in this position right now. I understand, it's true.
Honorable AG, we do need to consider the court obligations of the lawyers here, because we do need to get the lawyers' input in this.
I promise you I have a lot of work on my plate too, you know.
What we can do is, if we have the time for reflection, we obviously are not going to come here and start all over again in terms of looking at the clauses. Whatever assistance we can give you between now and then, we can share our views with you, and you can have a look at it. And then we can come back here, and whatever needs to be trashed out between now and then, I think we could get it done in a shorter period of time, having regard to the adjournment.
That's a reasonable position, Madam Chair, if you permit this discussion, and thank you. My fear is, and again I'm laying my cards on the table, that when we start at 1:30, by the time we get through question time, etc., and several hours, then we're now running at risk in terms of bail. And I'm very mindful that next week is the last week of the sitting of the Parliament, full stop. There's no other time before the recess hits us. So I'm most respectfully craving the indulgence of honorable senators to try and come in a little bit earlier. I know it's a hard push.
What do you want to do? What do you want to do? 12 o'clock? 11? You want to do 11?
We say about 11:30.
And the last submission I'd make on this is just that it's really, the earlier start time is really an attempt to try and avoid us staying as late as we do, and that's really a serious indulgence, not only on honorable senators, who I thank, but also the parliament staff. I mean, I myself, I've been sitting every single day in both houses, so I appreciate what's happening. So it's in the overall consideration, and tonight, for very good reason, we took 2 hours to do 2 clauses. I mean, I don't make a complaint about that because we came out with a better product. So respectfully, I'm asking honorable members to take the little extra stretch so that we can try and finish at a more reasonable hour for the entire Senate.
Madam Chair, I'm suggesting, in the spirit of a compromise, that we assemble at 11:30 on Tuesday of next week. And probably we could cut off at 10 and then come back on Tuesday, and we start at 10 in the morning or 10:30, but you have cabinet, so you won't be able to make it. So we're like about 2:30. So you understand the challenge that we have? So, Madam Chair, I would like to suggest to the Honorable Attorney General and the acting leader of government business that we compromise and we come at 11:30.
Sure, Madam Chair, I'd be pleased to agree to 11:30. I have not heard the honorable independent senators, but 11:30, and that we go until we finish.
You know, I do not have a whip, Honorable Attorney General, but I think that 11:30 seems to be a good compromise. Unless my colleagues object strenuously, I think 11:30 is something that we can start with and hopefully finish at an appropriate time.
Thank you, honorable senators. Madam Chair, thank you for facilitating the discussion.
So you just have to read it up.
Procedure. Just going to read a motion now. Procedure on the top here.
Yes.
Members, we're still in session. Senator Sturge. So, the Attorney General.
Madam Chair, in accordance with Standing Order 6814, I beg to move that progress on the bill be reported to the Senate.
Honorable Senators, the question is that progress on the bill be reported to the Senate. Those in favor say aye. Aye. Those against say no. The ayes have it. The Senate will be resumed. Attorney General.
Madam Chair, sorry, Madam President, I wish to report that the bill entitled An Act to Establish a System of Plea Discussions and Plea Agreements and for Matters Incidental thereto was considered in committee. However, the deliberations of the bill were not concluded, and I therefore seek the leave of the Senate to resume committee stage on Tuesday,
July the 4th.
The
4th of July.
4th of July, 2017, when the time will be announced that the motions are due in the House. Thank you, Madam Chair. Madam President.
Honourable Senators, the question is that the committee stage of the bill be resumed on Tuesday, the 4th of July, 2017. Those in favour say aye.
Aye.
Those against say no. The ayes have it. The committee stage of the bill will be resumed on Tuesday, the 4th of July, 2017. Minister of Labour and Small Enterprise Development.
Madam President, I beg to move that this Senate do now adjourn to Tuesday, 4th of July at 11:30 a.m. to go back into committee stage and to focus on the bail amendment bill, and if time permit, we'll also deal with the preliminary inquiry bill.
Yes.
Senators, before I put the question on the adjournment, leave has been granted for a matter to be raised on the motion for the adjournment of the Senate. Senator Mark.
Thank you, Madam President. Thank you very much. This is a matter that deals with the Sugar Industry Labour Welfare Committee. Madam President, this committee demitted office on September the 12th, 2015. And this is almost 2 years after. And the cabinet who finds time to reshuffle its members, they are yet to appoint a new board to this particular body. Madam President, I do not want to attribute reasons at this time, but I would like the government to indicate to this country, why has it taken 2 years to appoint the Sugar Industry Labour Welfare Committee Board? Madam President, in the absence of this board, a number of operations of this body have come to a halt. Several projects have been halted. Madam President, there are some 24 housing development projects for which only the board can take action on. Whether it deals with infrastructural works, the fixing of roads, legal matters relating to these particular housing development projects, the board has to take responsibility. Madam President, whether it is the question of mortgage payments, the board has a role when people need to get conveyances so they can get releases on their properties. We understand that there are some 764 mortgages that are outstanding. Madam President, the backlog on deeds that are to be provided to these owners of property because of the lack of conveyances that only the board can deal with is a real problem as we speak at this time. And in the absence of the board, what is happening is that empty lots cannot be handed out to these workers. And we are talking about cane farmers and sugar workers. I don't know what the government have against cane farmers and sugar workers. They have closed down Carney Green. They closed down Carney in 1975 Limited. And now they are denying the rights. Madam President, let me just cool myself. Madam President, I don't know what is the reason. But there is no plausible reason, Madam President, for this government not to have taken action to deal with this matter. Madam President, whether this body is responsible for the sewer systems, involving housing at Brother Gat's area, that is in Princestown, the Taruba area where there's quarter regularization that has come to a halt. There's the Orange Field development area, Madam President, where where workers were given VSEP, and they need to get their land regularized. And these projects cannot be open because of the absence of this board. WASA, TNTEC, and other utility bodies cannot function because of the absence of this board. Madam President, what is even more alarming is that this PNM government allocated some $8 million in 2016-2017 for the PSIP, for this body. And that money is going to be returned to the consolidated fund because of the absence of a board. Now, Madam President, as I said, whether it is the there's something called the Home Improvement Grant, the Home Improvement Subsidy. All of these things can be offered to these workers, but because the board is not functioning, you have a challenge. What is the problem? Is it political discrimination? What is the reason, Madam President? Why is the government of the PNM that says, let us do it together, and they stand for national unity? Why, Madam President, after 2 years, the government has failed to appoint that board? Madam President, I'm a member of a committee of this Parliament, and we had the Ministry of Housing and Urban Development before us because they are responsible for this body. And we asked the question, and the lady who came before us couldn't give us answers. So I told her the next time I am going to make an appeal to the board, to our committee, so we can bring to that committee, kicking and screaming, either the Prime Minister or Randall Mitchell, the Minister of Housing and Urban Development, so they can tell us what, the Honorable, but I want them to honor his commitment to the people who are members of the sugar area, Madam President. So, Madam President.
Members, please. It is too late now for this kind of behavior. Senator Mark, continue.
So Madam President, all I'm asking is for justice to be shown towards these workers and cane farmers and sugar workers. All they are begging for and appealing for is the appointment of a board, and the government of Trinidad and Tobago under the Honorable Keith Rowley is responsible for doing so. There's a cabinet board committee or committee that deals with the appointment of boards. Please do what you have to do and appoint the members of this Sugar Industry Welfare Committee. That is all the people are asking, and they're appealing to the government, Madam President. I thank you very much, Madam President.
Minister of Agriculture, Land and Fisheries.
Madam President. Madam President, as we came into the year 2000-2001, Australia and Brazil and other low-cost sugar-producing countries brought a case to the WTO, which eventually led to the dismantling of the long-standing preferential treatment that Trinidad and Tobago sugar enjoyed. In advance of the dismantling of that preferential treatment, Madam President, and in answer to my colleague, Senator Mark, it was a PNM government that took the decision to offer to currently 1975 workers, sugar workers, an unprecedented VSEP package, which has resulted in each worker who has applied receiving a 2-acre parcel of lot, and each worker who qualified receiving a residential parcel of land. More than 8,000 sugar workers, Madam President, are entitled to these agriculture plots, and more than 7,800 are entitled to a residential plot. This VSEP program has so far cost taxpayers more than $10 billion. Madam President, at the end of the VSEP and the distribution of these lots, a Caroni worker who received a residential lot, and these lots are free, currently holds an asset that is valued at least $450,000, and in some cases, like those who have gotten lots in Caroni Savannah Road, the asset is worth $750,000. In the case of the agricultural plots, those workers who have benefited from a 2-acre agriculture plot hold an asset that is valued at a minimum of $140,000, and in some cases $450,000. So those sugar workers, Madam President, under the hands of the People's National Movement government, currently hold on average land asset worth at least $1 million. Madam President, the Sugar Industry Labor Welfare Committee has a long history dating back to 1948. The Sugar Industry Labor Welfare Committee is one of 3 funds which were funded out of the proceeds of the export of sugar. And a long time ago, Trinidad and Tobago stopped exporting sugar. In fact, in 2003, and thereafter under SMCL in 2005, 2006, somewhere around there, Trinidad stopped exporting sugar. And once we stopped exporting sugar, the rationale and the funding for the 3 funds, including the Sugar Industry Labor Welfare Committee, simply disappeared. And since then, Madam President, up until 2015, September 2015, nothing had been done to address the issues of the funding and the future of the Sugar Industry Labor Welfare Committee. Since then, Madam President, the Minister of Housing has been engaged in a review of the Sugar Industry Labor Welfare Committee in order to put the funding on a firm footing, and in order to deal with those issues which Senator Mark pointed out, issues of mortgage, leases, loans which are in transition, and other matters relating to this long-standing organization. Madam President, Minister of Housing has completed his work and has placed before the Cabinet of the country a recommendation for the appointment of a new board charged with new responsibilities to take care of the future of what remains of this long-standing part of our sugar history, the Sugar Industry Labor Welfare Committee. I'm confident that the board would be in place and the board will take charge of what remains of the affairs of the SILWC and those sugar workers who benefit from that entity. Thank you very much.
Honorable Senators, the question is that this Senate do now adjourn to Tuesday, the 4th of July, 2017 at 11:30 a.m. Those in favor say aye. Aye. Any against? The ayes have it. This Senate now stands adjourned to Tuesday, the 4th of July, 2017 at 11:30 a.m.